Okay, good afternoon, ladies and gentlemen. Are we ready? Good. Claimants ready, respondents ready? Okay, well, we very much appreciate all the cooperation so far. We will now hear the respondents' opening. And at some point, I hope there will be some brief mention of the rejoinder, because the tribunal was sort of struck that the rejoinder did appear to raise some issues that varied from the positions previously taken, and raised some new issues, and at a point where, just as a procedural matter, claimants did not have a written opportunity to respond to that. And I just wonder, is that something that should concern us, or do you regard that as quite appropriate? I see a nodding head, and you'll explain to us why that's so. All right, over to respondent.
Thank you, Mr. Chairman, for that question, and we certainly can address that at more length. I think the preliminary reaction, Mr. Chairman, Mr. Chairman, that this is perfectly normal. It's the dynamic in any arbitration where each side will respond to the arguments that are being made by the other party in its previous submission. We have heard claimant argue in the skeleton that Peru has submitted new arguments. We disagree with that. We have been responsive.
I don't want to argue the thing with you now, but it used to be the case that there are only 2 or 3 regulatory requirements left to be addressed. That was the state of play after the counter-memorial, rejoinder, and then we get to the final pleading, and suddenly we have a whole raft of new regulatory requirements that had not previously been discussed. And you'll tell us why you think that's appropriate.
Okay, thank you.
Good afternoon, Mr. President and members of the tribunal. My name is Paulo de Rosa, and I will be introducing Peru's opening argument by giving a brief overview of the reasons why claimant's case must be dismissed. Claimant's claims revolve around 2 main sets of actions. The first is the actions of the Paran community, the poor rural community that we've been talking about that was in the direct area of influence of claimant's mine in Peru. The second set of actions relates to the Peruvian government's response to the social conflict between claimant and the Paran community. That social conflict culminated in a series of incidents, including at the mine in June of 2018 and at the main access road to the mine in October 2018. Claimant ultimately was unable to reach commercial exploitation, leading it to default on its financial obligations to its lender. As a result of that default, claimant forfeited its project company, Invicta, to claimant's lender. At its core, this case centers on the issue of what constitutes an appropriate government response when a social conflict has erupted between a foreign investor and local communities. As events in Peru and other countries have shown, such conflicts are delicate and often volatile. A state's response to such a situation involves a careful balancing of public policy considerations of the sort that are classically within the realm of a state's sovereign prerogatives. Peru submits very respectfully that the tribunal should not second-guess Peru's decision to forego the use of force against the Paran community members. Equally, the tribunal should not second-guess Peru's decision instead to favor dialogue as a way to achieve a peaceful and definitive resolution of the social conflict. Peru had already resorted to force in prior mining projects, in many instances with disastrous and long-lasting consequences. By contrast, dialogue had been productive at different times even in the Peron conflict itself, such that a successful negotiated outcome was entirely within the realm of the possible. Peru has demonstrated in its pleadings, and we will recall in this presentation, the various fundamental flaws that warrant dismissal of claimants' claims and arguments. Specifically, Peru has shown that the tribunal lacks jurisdiction, that the claimant's claims lack merit, and that in any event, no damages would be due. My colleagues will discuss each of these grounds for dismissal in more detail, but by way of introduction, I will provide a high-level overview. Starting with jurisdiction, the first of Peru's objections is that the tribunal lacks jurisdiction ratione personae. The basis for this objection is that when it transferred its shares in Invicta to its creditor, PLI Huawara, in August 2019, claimant failed to retain the corresponding claim rights. As a result, claimant no longer qualifies as a quote-unquote investor under Treaty Article 847. The case law establishes certain key principles that are relevant here. First, an investor's standing must be assessed as of the time that the relevant arbitral proceedings were instituted. Second, and subject only to two exceptions that I will discuss, the general rule is that tribunals lack jurisdiction if an investor has already disposed of its investment before the relevant arbitral proceedings are commenced. The two exceptions are first, when the investor has expressly retained its right to pursue claims, and second, when there are special circumstances, such as when it is precisely the state's actions that cause the investor to dispose of the investment in the first place. However, neither of those exceptions applies here. Peru's second jurisdictional objection is that the tribunal lacks jurisdiction ratione voluntatis because it is an undisputed fact that claimant failed to provide a waiver from Invicta as required under Article 823.1e of the treaty. Turning now to the merits, claimant's claims fail for several reasons. As claimant itself has acknowledged, it could not commence commercial production without resolving a social conflict with the Peron community. A fatal problem for claimant's merits case is that the social conflict was caused by claimant's own actions, not by any actions or omissions by Peru. Not only did claimant create the problem itself, but it was also within the claimant's power and ability to resolve that social conflict. Instead, claimant opted to resort to the use of force and insisted that the state clean up the mess that claimant itself had created. Ultimately, claimant's failure to reach commercial exploitation by the contractual deadline established under its financing agreement led it to forfeit its investment. Now, claimant has openly acknowledged, including in its pleadings in this arbitration, the significant and sustained efforts that were undertaken by various Peruvian state organs to find a resolution to the social conflict. Multiple agencies and government officials of Peru bent over backwards over a prolonged period of time to broker an agreement between claimant and the Peron community. The evidence shows that Peru acted diligently and reasonably at all times. Cognizant of the fact that Peru did not create the conflict and that, to the contrary, Peru had strenuously attempted to resolve it, claimant attempts to impute the actions of the Peron community to the state. But the Peron community's actions are not attributable to Peru under either domestic or international law, and therefore cannot form the basis for responsibility under the treaty. Finally, much of claimant's merits case is founded on baseless, made-for-arbitration conspiracy theories, including new ones that they advanced for the first time in their reply. We will briefly address each of these issues in turn. It is not in dispute between the parties that unless and until the social conflict with the Paran community was resolved, claimant would not have been able to commence commercial exploitation of the Invicta mine. The conflict in turn caused claimant to default on its financing agreement, as I mentioned. And given that, and since the Paran community's actions are not attributable to Peru, there is no basis to impose responsibility under the treaty on Peru. Claimant failed to design and implement an adequate community relations strategy. They simply failed to obtain what is known in the mining industry as a social license to operate. Under relevant international law principles, worldwide industry standards, and Peruvian law, mining companies are required to develop relationships of trust with the local communities. They are required to obtain adequate support from those communities both before and during the lifetime of the mining project. Importantly, and contrary to claimant's apparent position, this entails more than just meeting minimum legal requirements. Without a social license, a mining project simply cannot succeed. In this case, claimant failed to obtain sufficient community acceptance of the Invicta mine. They mismanaged the relations with all three of the rural communities that were in the area of direct influence of the project. And its failures were especially acute with respect to the Paran community, especially after, at some point, claimant erroneously concluded that it no longer needed the acceptance of the Paran community and therefore progressively began to marginalize that community. Now, given the Invicta's mine's location, the buy-in of the local communities was critical. It was critical because of the potential environmental, social, and economic impact of the project, particularly on the Paran community, given its proximity, as well as the ongoing territorial disputes between the various communities. A key threshold problem in claimant's handling of its investment in Peru, as well as in its pleadings and in its presentation this morning, is that the claimant has consistently dismissed this concept of the social license.
Counsel, I'd like to ask a couple of questions about that, but this is an overview, right?
Yes.
So there will be
We'll come back to
more
this.
detailed.
Yes.
All right, thanks.
The social license was an affirmative requirement, and the reality is that claimant's community relations strategy was insufficient for the purpose. Its engagement was particularly inadequate with the Paran community, and it progressively began to marginalize that community in favor of the other two communities. Claimant had inherited certain agreements with the Paran community when it took over the project, but it then discarded them as unnecessary, refusing to abide by prior commitments that it had made to the community or to honor community expectations. And in the end, as you know, they chose to resort to the use of force by deploying the war dogs to expel the community members forcibly from the mine site. That was what caused this confrontation that yielded the fatality that the claimants referred to earlier today. Now, that aggressive step and the ensuing violent confrontation with the Paran members destroyed any prospect of an amicable resolution to the social conflict. And as a result of that unresolved conflict, claimant was unable to commence commercial exploitation of the mine. And as a result of the violation that entailed of the PPF agreement, claimant forfeited its shares in Invicta and lost its investment in Peru. Now, as you can see on the screen, claimant itself has acknowledged in its reply at paragraph 351 that Lupaka lost its investment on 26 August 2019 when Lonely Mountain, which was PLA Huaura's owner, seized IMC's shares following Lupaka's failure to service its obligations under the PPF agreement, close quote. One of the fatal flaws in claimant's legal position is its hypothesis that the actions of the Paran community are attributable to Peru for purposes of state responsibility under international law. That hypothesis is entirely wrong under the principles of attribution under the ILC articles, as we will discuss in more detail later in this presentation. Now, tellingly, the contemporary documentation shows that at the time of the Paran community conflicts, even claimant itself did not consider the community to be a state organ or to be empowered with state functions or to be acting in the exercise of government functions or state authority. To the contrary, claimants consistently viewed and characterized the Paran community protesters as private actors who were acting illegally. That inconsistency between the evidence and claimant's position reveals the made-for-arbitration nature of claimant's attribution arguments. Now, turning now to Peru's response to the social conflict. None of Peru's actions violated any obligation under the treaty. First, Article 805 of the treaty provides that the fair and equitable treatment and full protection and security obligations are limited to the minimum standard of treatment under customary international law. And it is well established that a claimant alleging a breach of the minimum standard must meet quite a high threshold with respect to full protection and security, which lies at the core of claimant's claim. Professors Dolzer and Schroyer have noted that the relevant standard requires that a state, quote, exercise due diligence and take such measures to protect the foreign investment as are reasonable under the circumstances, close quote. Claimant has not challenged that this is the applicable standard, although there are certain differences in the parties' interpretation of that standard. And with respect to fair and equitable treatment, we have placed on the screen the well-known articulation of the minimum standard threshold that was offered by the Tribunal in Waste Management 2. According to that formulation, state conduct will only breach the minimum standard if it is, quote, arbitrary, grossly unfair, unjust, or idiosyncratic, or discriminatory, or if it involves a lack of due process leading to an outcome which offends judicial propriety. Claimant has accepted this as the relevant standard, and that's at claimant's pre-hearing skeleton, paragraph 90. The core allegation in claimant's merits case is that the Peruvian government should have used force to resolve claimant's social conflict with the Paran community. But Peru's decision not to use force and instead to try to mediate a peaceful and durable resolution to the dispute was entirely reasonable under the circumstances. It did not breach the minimum standard of treatment. The tribunal's analysis of Peru's actions must take into account the relevant circumstances, which in this case included the history of social conflict in the Peruvian mining sector, the catastrophic consequences of the use of force by the state in Peru and elsewhere in prior mining projects, and the success that had already been achieved in negotiations between these particular conflicting parties. For example, the negotiations yielded the 26 February 2019 agreement, which is Exhibit C200. All of these circumstances weighed heavily against the use of force to address this particular social conflict. Claimant argues, however, that Peruvian law obligated the authorities to use force against the Paran community. And they repeated that again this morning. But Peruvian law imposes no such requirement, as we have shown, including on the basis of an independent expert report. But perhaps more importantly, there were good reasons not to use force in this case. First of all, a forceful eviction of the protesters who were involved in the access road protest would have succeeded only in ending that particular protest. It would not have resolved the dispute for good, and it would not have prevented similar protests in the future. Those were bound to continue until the underlying issues were adequately addressed. And second, dialogue appeared to be the most promising avenue for a lasting resolution to the social conflict, given the prior successes that the parties had already achieved through negotiations. The bottom line is that Peru's actions in seeking a negotiated solution to the social conflict were reasonable and justified under the circumstances, and there was therefore no breach by Peru of its FET or FPS obligations under the treaty. Claimants' expropriation claims similarly fail. First, there was no direct expropriation in this case, not only because the access road protest was not attributable to Peru, but also because there was no transfer of title or outright seizure by the state of claimant's investment. Nor was there an indirect expropriation. Treaty Annex 812 expressly identifies the elements of an indirect expropriation, but none of those are present here. For these reasons, the tribunal should honor the presumption established under Treaty Annex 812 that good faith non-discriminatory measures in the public interest are non-expropriatory. Our final observation on the merits issues is that claimant attempts to distract from the defects in its case by conjuring up a series of fanciful conspiracy theories. These include, for example, that the community actions were motivated by a desire to protect an alleged community-wide marijuana business, that the Paran community staged its protests to steal the mine for itself, and that a government official, Mr. Roman Retuerto, had spearheaded the June 2018 protest and had generally fueled opposition to the project. And you will hear from Mr. Retuerto later this week. However, as Peru has demonstrated and will recall again today, there is zero credible evidence to support any of these conspiracy theories. We turn now to the final prong, which is damages. Even if claimant had established jurisdiction and liability, which it has not, its damages claim would fail for several reasons. Those are summarized on the screen, but just for reference, but in the interest of time, we will not read them since we will address them briefly sequentially. The first reason is that there's no causal link between Peru's conduct and the loss of claimant's investment. Claimant lost its investment because the social conflict, which claimant itself precipitated, prevented claimant from reaching commercial exploitation in the time required under its financing agreement. And that in turn caused it to forfeit its investment to its creditor, and none of that had anything to do with Peru. Claimant, for its part, argues that it was Peru's decision not to use force that caused the loss of the investment, as I mentioned. Now, claimant has focused heavily on this throughout the arbitration, including in the presentation this morning. However, as we have stated, an operation by the Peruvian police to terminate the protest by force would not have resolved the conflict permanently. And this is something that even claimant's own witness, Mr. Julio Castañeda, acknowledges at paragraph 74 of his witness statement, which we have on the screen, where he said, quote, "We knew that the Paran representatives would not be deterred for long, and that once the police had left, the site would again be at risk of invasion. For this reason, we persisted in our efforts to secure an agreement with the Paran community," close quote. So the bottom line is that having the police forcefully quash the protest would not have enabled claimant to resolve the social conflict or otherwise to reach commercial exploitation any sooner. In any event, even absent the access road protest, claimant would not have avoided a fatal violation of its financing agreement with its creditor and the resulting loss of its investment. The PPF agreement required commercial exploitation by December 2018, which was only 2 months after the access road protest. That means that even if the access road protest had been quashed by force by the state, or indeed even if the access road protest hadn't happened at all, claimant would still not have been able to reach commercial exploitation in time. And that's because at that point, claimant still lacked key permits and adequate ore processing facilities to commence exploitation. And another reason why claimants' damages fail is that their damages model is defective and unreliable. It includes a number of flawed assumptions and defective calculations, and we've listed those on the slide. We'll discuss them later in this presentation. Now, even if claimant did not face the causation, contractual, and methodological problems that I just alluded to, any damages awarded in this case would need to be reduced sharply to account for claimant's contributory fault. Claimant contributed to the loss of its investment with numerous failings of its own, including defective due diligence, failure to obtain the social license, acceptance of risky financing arrangements, failure to obtain requisite permits, failure to obtain adequate ore processing facility, and its own breaches of the PPF agreement with its creditor. Mr. President, members of the tribunal, this concludes our introductory overview. I will now yield the floor to my colleagues to present the remainder of Peru's opening arguments. Starting with my colleague Patricio Grané, who will identify the key disputed and undisputed factual issues. Then my colleague to my left, Timothy Smythe, will explain why the tribunal lacks jurisdiction and why the Paran community actions are not attributable to Peru. Then Mr. Grané Labat will return to explain why claimant's claims fail on the merits. My colleague Brian Bombasaro will demonstrate that no damages should be awarded in any event. And finally, Ms. Vanessa Rivas Plata Saldarriaga, the president of Peru's Special Commission for International Disputes, will conclude our presentation with a few closing remarks. Thank you very much for your consideration.
Members of the tribunal, the parties agree that much of the factual record in this arbitration is undisputed, but they disagree about the characterization, the significance, and the legal implications of certain key facts, particularly in relation to the following key issues. One is the context surrounding the claimant's investment. The second is the claimant's mismanagement of its community relations. The third is Peru's reasonable response to the conflict, the social conflict between claimant and the Paran community. The fourth is the breakdown of claimant's relationship with the Paran community due to claimant's own conduct. And the fifth is the claimant's loss of its investment to its creditor, PLA Wauda. In the present segment of this opening, I will address the key facts pertaining to those issues. Now, I do not anticipate raising any confidential information, but following the hearing, Peru will work with a claimant to confirm that any reference to such confidential information, in particular that referring to one specific witness, it is redacted in conformity with Section 47 of Procedural Order Number 6. I will begin by addressing the context surrounding claimant's investment, which is the first issue that I identified. Now, mining in Peru, as much in Latin America, has often given rise to social conflict between mining companies and the local communities. This is not new. Communities located in remote, impoverished rural areas of Peru often feel harmed by the environmental impact of mining activity and the fact that they are denied the opportunity to share in the economic benefit of such activity. Where forceful police intervention has been used to try to quell community opposition or protests, devastating consequences have followed, including in the intervention in Bagua in 2009, where scores of local residents and police officers died and hundreds were wounded. Now, given that reality, Peru has developed practices, regulations, and standards that call for community engagement by mining companies with the local communities and to prioritize dialogue over the use of force. Now, contrary to what you have heard from claimant, the social license is acknowledged by the mining community as a critical requirement for mining projects. At its core, it consists of a mining company's need to obtain acceptance and trust of relevant communities and stakeholders even before commencing mining activity. Without a social license, mining projects are exposed to high risk and often violent opposition from local communities. Now, Peru and Canada, parties to the treaty invoked by claimant, jointly published a communications and community relations toolkit for responsible mining exploration. This is in R28. Now, this toolkit expressly contemplates the consequences of a mining company's failure to manage its community relationships, including blockades, as you see on your screen, which is an excerpt, a graph that's contained in this toolkit. And you will see, and we will revisit this graph throughout our presentation because it largely tracks the facts of the present case. Now, contrary to claimant's argument in this arbitration, including in its opening statement today, the concept of social license is also reflected in Peru's legal framework. Now, some examples are highlighted on the screen and described in more detail in Section 2A1 of Peru's rejoinder. Now, as the record...
I think that this is the appropriate time to ask a couple of questions on social licensing. As I understand your briefs, the assertion is made that a mining company, like as in the position of Invicta, has an obligation to obtain and maintain social licensing from the communities in the area of influence of the project beyond the specific obligations imposed by the law in connection with the environmental impact statement, right? That's the way I understand your argument to be. Let's put aside the question of what the origin of that obligation is, but you have asserted that there is an obligation of the mining company. So my first question is this an obligation of result or is this an obligation of means?
Thank you, Mr. Garibaldi, for that question. It is an obligation of result in the sense that the lack of that social license will have consequences. Now,
okay, so it is an obligation of result. Fine.
Well, I'm sorry, if I may. It is an obligation of result in the sense that the failure to obtain that will have the consequences that have been identified by the mining industry and this toolkit. Now, as to means, the Peruvian regulations, including the ones that you have on the screen, are created precisely to determine the ways in which mining companies should try to obtain that social license. So we cannot divorce the result aspect from the means.
No, I understand that, but we are talking about an obligation of result which goes beyond the means expressly established by Peruvian law. Is that right?
No, Professor Garibaldi, again, if I may, it's very tempting to try to reduce the social license to a single provision. And that's indeed what claimant has tried to do in this arbitration by saying you cannot point to any specific law that has the term social license. Social license, as the evidence...
I'm not talking about that. I'm not talking about that. I'm trying to understand your own argument. Your argument is that there are certain specific obligations imposed by the law. Let's put them aside. But you also say that beyond those obligations, there is social license, which is more than that. And there is an obligation to obtain and maintain that social license from the affected communities. So with regard to that, I am asking, is that an obligation of result or an obligation of means?
I couldn't answer that question, Mr. Garibaldi, without providing the explanation about the concept of social license and how it is reflected. It's not a simple concept that has a single reflection in any provision. It is a complex, broad concept that has different manifestations at different times, both in the exploration and exploitation. So I'm afraid that I cannot provide an
so
answer
you cannot
that
tell me
chooses
if
between...
you cannot tell me if the obligation that you call this obligation to obtain and maintain a social license is an obligation of means or an obligation of result?
I would say that it's both. If I am forced to provide an answer, I would say that it's both because of this complex,
Okay.
broad concept of social license.
All right, fine. So you maintain that it is an obligation of result, at least?
In the sense that the consequences of not
All right.
obtaining that social license will have the consequences that we have
fine.
seen in this case, and that the mining industry warns companies
All
would
right.
result from not obtaining the social license.
Fine. Second question. This is an obligation of the mining company, is that right?
It is an obligation of the mining company, yes.
There isn't a reciprocal obligation of the local communities, is that right?
There's no reciprocal obligation by the local communities.
So in other words,
grant, when you say obligation, do you mean to grant the social license?
Exactly.
No, there's no reciprocal obligation to grant the social license.
all right. Well, that will do for the time being. I wanted to clarify your own opinion about this obligation. Okay, go ahead.
Thank you. And I restate that it's not a binary option of saying results or means because of the nature of the social license.
Let me just briefly follow up with a question. I mean, I'm struck by the sort of geographic breadth of what we're talking about. We had the testimony of one witness that 55% of the mountain areas of Peru were covered by rural communities or indigenous communities. So we're talking about a great deal of real estate here. So this seems to have quite broad consequences. Would it be acceptable, in your view, if social license could not be obtained because, for example, a community didn't like Canadians?
No, Mr. President.
But you told us there's no obligation on their part. Presumably, whatever factors they regard relevant can go into their decision.
Well, there's no obligation by the communities to grant the social license, but I understood your question to refer to the justification that a community may have to reject a project.
Right.
And of course, it wouldn't be justified to reject a project on the basis merely of discrimination.
Well,
But
but on the other hand, we are told that it is entirely up to the community to determine whether to grant social license.
It's entirely up to the community to decide whether the factors are in place for the project to be acceptable to that community, which does not mean that any opposition can be simply disregarded. You have to look at the nature behind
I mean, humor me here. Let's suppose that the objection of a community was that we don't like Canadians, and we therefore do not think your project should go forward. What consequence in the real world then happens, if any?
Well, I think that in that case, the mining company would understand that the rejection of the mining project has at its core something that cannot be addressed. And therefore, the engagement with the community has to be such that the local community understands that it's not in the interest of that community to simply resort to nationality, for instance, as a reason to reject the project. And this is where the communication comes in. The mining company...
So it's incumbent upon them to somehow go in and persuade the community that Canadians are very nice people and they should not persist in this objection.
To engage the community, to persuade them that Canadians are very nice people, which indeed
the
they are,
last
but more importantly, Mr. Chairman, that the mining project does not pose a threat to their well-being, the environment, and that it could contribute to the social and the economic development. And this is where the engagement and the communication is.
Right. And at the end of the day, the engagement and communication does not succeed. What then?
Well, what then? You find the consequences that you see in this case. Now, how you
All right,
deal with
at that point, then the investment fails because they're Canadians, to use my hypothesis.
It's a hypothesis, Mr. President, that, unfortunately, is one that is not quite so simple in the real world. I don't think that there can be a mining project that can simply be dismissed because, the community considers that the
Right,
nationality of
But
the...
I'm just a little concerned because we have representations by the claimants. I know you don't accept them and you regard them as ill-founded, but they are representing that at least certain people influential in the community work to block agreement for, we'll call them improper reasons.
We dispute the facts and the implications that
Right.
they're trying to draw from that.
But let us assume that the facts are as they assert. What consequence then?
Well, the consequence is what you have seen, where the insistence of the claimant to find a quick solution ignores the concept of social license that requires a long-term engagement to gain that acceptance by the local community.
Okay, well, thank you very much.
And I think that this shows again that the risk of having this very narrow understanding or interpretation of a social license. It is not a box-ticking exercise, as claimant has attempted to argue before this tribunal. And at the end of the day, the ignorance behind the concept of social license leads to the consequences that we have seen and that are identified in that toolkit that you saw on screen. Now, to obtain the social license to operate, claimant needed to obtain and maintain, as Mr. Garibaldi has said, the acceptance and trust of each of the three rural communities in Invicta's area of the direct influence. And as you know, those three communities are Paran, Laxanga, and Santo Domingo. Now, originally claimant admitted, and this is important, originally it admitted that it needed the Paran community's support, but later it wrongly concluded that it did not. And it reached that conclusion on the basis of a change in the Invicta's project scope in 2004. That is what they have said. But 2014, not 2004. But that 2014 change neither significantly altered the physical location of the mine's infrastructure, nor rendered the Paran community immune from the mine's negative impact. Now, this morning, opposing counsel said that, and I quote, significant reduction in the social footprint of the project. Now, that is untrue. There was no significant reduction in the social footprint of the project in 2014. When Peru approved a supplement to the Invicta's Mine Environmental Impact Assessment in 2015, after that scope change, it noted that, and I quote, the mining components will be located within the area of direct and indirect environmental influence approved in 2009 without any modification. This is in C40, page 4. Now further, claimant's dismissal of the Paran community's support is formalistic and wrong for at least three primary reasons. First, the Paran community's crops and villages lay within the mine's area of direct influence, mostly downstream and downhill of the mine, where they would be more exposed to the effects of water pollution. And second, several of claimant's water management facilities and an access road to the Invicta mine were located on Paran territory. And third, the rural communities disputed the ownership of the territory where the Invicta's mine infrastructure was located. And contrary to claimant's argument in the skeleton, such argument was not new when it was raised in the rejoinder. Rather, it was responsive to claimant's argument that an agreement with the Paran community was not needed because the mine was not located in the Paran territory, according to claimant. And this is a memorial. If you want to track the evolution of that particular argument, you can look at memorial paragraph 72, counter memorial paragraphs 133 to 138, and reply section 3.2.2. Now, for these and several other reasons, obtaining acceptance by the Paran community was essential to the successful development of the mine, as later events have confirmed.
So, are you going to come back to the question of this disputed ownership of the land?
We certainly will, Mr. Garibaldi, and I believe that it will be, I believe not, I am sure that it will be the subject of cross-examination in the course of the week.
In your opening, are you going to come back?
Not in great detail.
Okay, I'm going to have a question then. I want to go quickly because I don't want to take a lot of time, and time is golden here. The question is this. There is a dispute, you say, between Paran and La Sanga and Santo Domingo about the ownership of, about a claim by Paran that it owned the area where the mine is located. Okay, and how is that dispute to be solved under Peruvian law?
There's a process of registration of the Paran communities and its boundaries. Now, at the time, at this moment, that dispute has not been resolved. But for instance, and we will see the evidence, and evidence is on the record, about, for instance, agreements between the communities that have settled part of that dispute, but not entirely. Now, again, it's a process under Peruvian laws and regulation that takes time and leads to the registration of boundaries in a public register.
All right. In the case of the dispute continues, what is the agency of the Peruvian state with authority to resolve that dispute?
I will have to come back to you on that question, Mr.
All right,
Garibaldi.
thank you.
Now, as I was saying, now obtaining this acceptance by the Paran community was essential. But however, claimant didn't obtain that, and in fact, it mismanaged its relationship with the Paran community. Throughout its engagement with the rural communities, claimant outsourced its community relations to a company that lacked the necessary experience and resources. Now, most of the projects cited by claimant as evidence that it had a qualified and experienced team refer to projects not yet in their exploitation stages, and nearly every relevant project involved significant social conflict and protests by the local communities. In any event, claimant dismissed this community relations team in November of 2018, which is shortly before the start of the Access Road protest in October of that same year. Now, this left claimant without its allegedly experienced team during the most critical point of its conflict with the Paran community. Now, claimant had a poor communication relation strategy from the outset. It delayed engaging with the Paran community about the project until 4 years after it acquired the project. In fact, it was only after claimant was approached by the Paran community that it began to negotiate with them. And even then, such engagement was focused primarily on claimant's attempt to secure community's permission to use an access road through its territory, which it later abandoned, and in the process planted yet another seed of the conflict that came later. Now, meanwhile, as Peru first addressed in the Counter Memorial, and it re-emphasized in the rejoinder in Section 2B2B, claimant prioritized relationships with the other two neighboring communities. Now, claimant consistently ignored the Paran community's request for an agreement. It failed to keep the Paran community informed of the process of the progress of the project, and contributed only nominally to that community, to the Paran community. But in contrast, claimant reached agreements with and continuously engaged and made contributions to La Sanga and Santo Domingo, the neighboring communities. And as noted in the toolkit, that graph that I presented earlier, adopting a selective relationships with local communities leads to blockades that result in the shutdown of operations.
Council, quick question. How do you relate your argument that they had a wholly inadequate outreach capacity with the fact that they seem to have reached rather substantial agreements with at least two of the communities?
Those agreements with those other communities were reached at a different moment in time. And the conflict with those communities, because there were certain conflicts with those communities that we will address, and we have addressed in the record, are nowhere near the complexity of the conflict that they had with the Paran community, which called for an experienced team that would be able to deal with the situation at that moment. It's very different to engage with the communities at an early stage and offer something. It's very different to deal with communities much later when there's already distrust and lack of communication and resentment towards the company. At that stage of a conflict, you need an experienced team as opposed to simply putting something on the table and waiting for acceptance.
Now, when you say at that stage, chronologically, what period are you talking about?
Well, the conflict with the Paran community started early, but it was in 2018 that you start to see the conflict escalating. In early 2018,
Thank you. We're talking 2018, essentially. Okay, thank you.
Council, can I pitch into this stage? Is it Peru's position that the screen?
I'm sorry, sir. Microphone,
Oh,
please.
I thought I had.
I'm sorry,
Is-
sir.
is
Please,
it
please
Peru's-
start over. Excuse me. I'm sorry, I
Oh.
couldn't hear.
Is it Peru's position that the discriminatory treatment of Paran compared with the other two communities was based on the fact that it wasn't sought to engage in the mining activities on the Paran land?
I think that discrimination, Mr. Griffith, has different manifestations. And again, we have to track this, and we will through the chronology. That engagement had different moments, different components. They have to comply with the social obligations that by law are required. Now, those social obligations, which are part of the environmental impact assessment, have different components. There's employment, there's social, there are economic contributions that need to be made. Now, throughout this relationship, the company and the community engage in a dialogue, and different offers are made to that community about how that community can become a stakeholder in the project. So there are different aspects to that relationship, that communication, that later will lead to Paran feeling that they had been cheated, that the things that were offered to them early on later did not materialize, and they were seeing their neighbors obtaining some of the benefits. So for instance, the access road is one example. Early on in the conflict, Paran was told that they would be given an access road. Later, they discovered that the access road had been given to Laksanga, to their neighbors, which led Paran at some point to tell claimant, when the conflict had erupted, to say, I want the access road, but claimant reacted late and rejecting that offer because they'd already had the Laksanga access road. So that's an example of how this engagement has different components, and in this case, that engagement with Paran was poor in comparison to Santo Domingo and Laksanga, which led to this conflict. But it cannot be reduced to only one item. Water pollution was another concern. Again, the engagement has to take into account social and economic development, but also, health, environmental issues. Now, you heard, and now that we are on the issue of the different things that the company said to the communities, and that I mentioned the environmental concern, that's an important part of the conflict that later on erupted. And you heard claimant's counsel this morning state that at no point did Paran flag concerns about environmental degradation. That is patently false, as shown by evidence on the record, including claimant's own witnesses. As one of the many examples of evidence on the record about Paran's racing water contamination as a concern is Exhibit R77 from April 2018. And here I go back to your question, Mr. President. Here's an indication early in 2018 that the Paran community was concerned about what the company was doing and the lack of engagement and the lack of information. Again, this is not a simple conflict where at one given moment it suddenly erupts. It's a buildup, it's an escalation. And here we see the seeds of that conflict. Early in 2018, April 2018, the community is telling the company, we are concerned about what we're seeing in the water, about water contamination. And later on, this is something that was continued to be raised and was the object of inspections by the regulatory agency that did find contamination, and I will get to that issue. So the Paran community did raise environmental concerns repeatedly, But claimant simply dismissed the Baran community's environmental concerns over the adverse impact that water contamination from the Invicta mine could have on its agriculture, which it's the community's main source of livelihood. Now, claimant initially disregarded these concerns and continues to do so today, as you heard, including in this arbitration, arguing that they are unfounded because, according to claimant, the Invicta mine was not located in the territory of the Paran community, as if water contamination knew boundaries. Now, claimant's arguments ignore the undisputed fact that the Paran community's villages and agricultural zones are closer to the mine than any other community, and they're downhill and downstream from its infrastructure, from the mine infrastructure, and within the area of the environmental impact of the project. And they're within that area as recognized by the environmental impact assessment. And it is also undisputed, as I mentioned a few minutes ago, that claimant was contaminating the water and was duly sanctioned by OEFA, which is the Peruvian Environmental Authority. And this is in Exhibit R74. It's a resolution from OEFA dated 27 September 2018, where OEFA confirmed that the Invicta mine was discharging toxic chemicals above permissible limits into the water, into the ground and water sources. And you can see the percentages on the screen of how much they were exceeding the tolerable levels of some of these chemicals. So this is, remember, Paran in April 2018 was saying we're concerned about the water. Claimant brushes aside that concern, and then in September, the regulatory comes in and confirms the concerns that the community had. And it is hardly surprising that the Paran community had a legitimate and well-founded environmental concern, which, again, claimant has dismissed offhandedly. Now, claimant also boldly asserts that, and I quote, it did not breach its social commitments. And this is covered in the reply section 4.3.3. Again, that is patently false. It is undisputed that claimant did not satisfy several of its social commitments to the communities and accordingly was sanctioned by the regulator. And we address this in reply, including or starting in paragraph 182, and I refer you to Exhibit R61. Now, a non-exhaustive list of claimant's breaches are listed on the slide. Perhaps they're not. We'll find the correct slide. I'm sorry, here it is. That's R61. I had moved too quickly. So essentially, claimant has fostered the perfect incubation conditions for a social conflict leading to the blockade and the shutdown of the operations, which again is the consequences of what you see on the left, the blockade, and ultimately what the blockade causes. And recalling from that, from this graph, from the toolkit, now claimant created unclear communication channels by outsourcing its community relationships, allowing its community relations team to contract to lapse, failing to consistently engage with the communities, and deliberately misleading the Paran community, saying, for instance, that there was no water contamination, promising things that it later did not deliver, but delivered to its neighbors. Claimant and Paran community also held different agendas, which is another of the causes of the opposition and the blockade. The Paran community wanted its environmental grievances addressed and to reach an agreement with claimant on terms that were similar to those secured by the neighboring communities. Now, claimant, on the other hand, saw Paran as a nuisance, as a problem to either ignore or neutralize. It thought that simply saying your water's not being contaminated because it's not in the area or your territory does not include the infrastructure of the mine means that there's no water contamination. That is simply not an acceptable explanation from the perspective of the community who is seeing the color of its water being unnatural because of the presence of the chemicals that were later confirmed by OEFA to be present in the ground and water sources. Now, claimant also engaged in selective relationships by prioritizing Laxanga and Santo Domingo over the Paran community.
Sorry, Counsel. So if we go back and dig in the record, we will find evidence to support the statement you just made that the discoloration of the
Yes,
water
sir.
was attributable to these excessive discharges of heavy metals?
Yes, sir. It's the only possible source of that discoloration of the water
Well,
was.
I'm asking, is there evidence in the record to
Yes, sir.
support
And
that argument?
R74 is one such piece of evidence.
R74, okay.
Now, finally, claimant failed to address the community grievances, as I said, by not reaching an agreement with the Baran community, disregarding its legitimate environmental concerns, delaying the settlement of its debt to the community, and blatantly failing to satisfy other social and monetary commitments. Another exhibit, in addition to the one I mentioned, would be C408. So the Baran community's opposition was hardly surprising. In fact, it was entirely foreseeable, and it led to the blockade. But while it was foreseeable, it was not inevitable. Claimant could and should have averted the opposition that led to the blockade if it had not completely ignored the concept of social license. Instead, and to this day, it has treated that fundamental concept with utter contempt.
I find something very strange here. You seem to be treating the blockade, which is an act of force against the law, against Peruvian law, as something inevitable, something like an act of God, something that is caused by certain actions and inactions of the mining company, but is something that is inevitable.
Quite the contrary, we are not treating it as an act of God, Mr. Garibaldi. We're saying that the blockade is the result of the conduct of the claimant that could and
but
should have been avoided.
Okay, let me rephrase that. The blockade is an act of a group of people, right?
Correct,
Which is against the law, isn't that right?
correct.
So, isn't there something? Isn't there an agency in between this causal relationship that you're talking about?
If what you mean by that is agency from the state, absolutely not.
No, it's agency. I'm talking about the community of Paran. I'm not addressing now the question whether the community of Paran is the state or not.
Mr. Garibaldi, there's no submission from Peru that the Paran community was not directly responsible for the blockade. It is the members of the Paran community that erected the blockade.
All right.
Now, what we are addressing, Mr. Garibaldi, are the causes that led to that blockade, and what I have just stated about the inevitability of that goes to the conduct of claimant, and it goes to the concept of the social license. And social license is recognized by mining communities because if it's not, the community is not engaged in a positive, constructive way, it leads to these situations.
Let me find one final question. Would it be possible, assuming everything else is the same conduct from the mining company, would it have been possible for the Paran community to refrain from an act of force?
It would have been possible, yes.
Thank you.
Now, we have established that the mismanagement of the community relations by the mining company led to the blockade. But what's important, and we will get to the issue of attribution, what's important is what the Peruvian authorities did to address that social conflict, of which it was not a party and which it had not created. Now, the evidence shows that Peru's authorities acted reasonably and in accordance with Peruvian law in attempting to mediate a lasting solution to a claimant's conflict with the Paran community. And this notion of the lasting solution is critical to understand the measures that can be taken in that type of situation where there's a forceful opposition by the local community. Now, in the months before the first Paran community protest in 19 June 2018, claimant had ceased dialogue with that community and was not performing its social obligations under the social management plan, again, which is a formal document that is required by Peruvian law, and for which it was sanctioned the company for not complying with that social management plan. Now, these actions were in direct violation of the company's obligations under Peruvian law. Now, 2 months before the June protest, the Paran community once again explicitly expressed to claimant its desire to reach an agreement with the mining company that would recognize that community as a stakeholder in the development of the project. Now, the community made it clear that it was open to receiving any proposal from Invicta, and this is Exhibit C 430. In May, the Paran community sent claimant another letter explicitly expressing its alarm that claimant had stopped dialogue with the community and was pushing ahead with its plans to develop the mine. And in particular, the Paran community was concerned about the possible activity at the mine that was already causing this contamination of water and land. And again, this is the second letter in May is Exhibit C 121. But claimant made no attempt to engage in a constructive dialogue, as I said, and build community relations. In a 3-letter paragraph dated 30 March 2018, which is C122, claimant callously dismissed the community's environmental concerns as misinformed and its territorial claims as lies. Now, that's hardly a constructive and forward-looking response to a community that is expressing concerns about what they're seeing the company do in what they consider to be their territory. But claimant sits here today and they spin a different story. But the evidence demonstrates that the Paran community felt ignored and marginalized by claimant and decided to express its discontent, its repudiation of that conduct by claimant. Now, in the absence of that positive engagement by claimant, the Paran community's concerns intensified, and particularly based on what its members were witnessing, which included a visible discoloration of the water, especially after heavy rainfalls, the use of explosives due to the general works at the mine, the presence of heavy equipment to the general works, and the sight of trucks filled with ore leaving the Invicta mine, which is the result of the testing that was being conducted by the mining company. Now, mind you, the testing resulted in at least 7 tons of ore being extracted from the site. And the Paran community was witnessing this. They were, of course, rightly concerned and understandably concluded that the mine was being exploited at that point by the mining company. Now, on 19 June 2018, approximately 250 members of the Paran community appeared at the mine to conduct an inspection. And in the course of that inspection, tempers flared and some property was destroyed. But claimant here grossly exaggerates what happened that day. And this also will be the subject of further discussion this week. But in any event, Peru responded diligently and appropriately to this protest by leading a police patrol. And throughout our presentation, we will refer to the police sometimes as the PNP, the Peruvian National Police. So a PNP patrol inspected the site following that protest of 19 June 2018. And claimant was grateful for this response by the PNP. And this is discussed in the pleadings. But unable to deny those facts, claimant offered several new theories in the reply to attempt to recast blame on Peru, even though, again, contemporaneously, they were grateful for the PNP's intervention that day. Now, first, and here we start with conspiracy theories. Claimant introduces a new and baseless conspiracy theory here in relation to the June 2019 protest. According to claimant, a low-level regional government official, Mr. Roman Retuerto, conspired and led the community's opposition against the project that day. Claimant's new argument was introduced after Peru demonstrated that its original claim, that is, based on the Paran community's actions being attributable to Peru, was hopeless and failed at the threshold. So, claimant sought to plug that gaping hole in its case theory, and it desperately sought a government official on which it could pin the blame. And this is where claimant falsely accuses Mr. Roman Retuerto of participating in and leading the 19 June 2018 protest. When Mr. Roman Retuerto learned of the planned 19 June protest, he alerted the proper authorities. And he requested that action be taken to prevent the conflict from escalating, and he called dialogue, and this is in C550. Notwithstanding this letter, claimant asserts that Mr. Roman Retuerto led the protest, but there's no evidence to support that allegation. And you heard this morning claimant saying that it relies on an internal report and the fact that someone saw Mr. Retuerto present at the site on 19 June 2018, just as police went to the site on the date of the protest. And yet claimant does not accuse the that members of the tribunal. And you will have an opportunity this week to hear from Mr. Roman Retuerto. You will see that he is an honest, a humble, and a soft-spoken man who was simply doing his job, and now stands accused by claimant because he dared to report to other state agencies what he was seeing. Claimant's argument in this respect is nothing short of frivolous. But let us return to claimant's mismanagement of community relations and the state's efforts to clean up claimant's mess. After Peruvian law enforcement authorities intervened to avoid a potentially violent confrontation between the parties in September 2018, claimant had an opportunity to reassess the way it had managed its relationship with the Paran community and to address the community's grievances. But claimant deliberately squandered this opportunity because it believed that the Paran community's grievances and demands stood in the way of its own goal of moving quickly towards exploitation of the mine. So this was in September 2018. Weeks later, on 14 October 2018, approximately 90 members of the Paran community established the Access Road protest, which is a civilian blockade roughly 300 meters from the entrance to the Invicta mine, the Bocamina, on the Laxanga access road. The authorities responded immediately, and de-escalated a tense situation. The Peruvian authorities also brokered an initial agreement between the parties to bring them closer towards dialogue. Over the months that followed, Peru activated a panoply of state agencies and resources to proactively and diligently mediate claimants' conflict with the Paran community. Peru's efforts in mediating constructive dialogue yielded the 26 February 2019 agreement, which is C-200. At the time that this agreement was signed, claimant's CEO publicly celebrated it and explicitly manifested claimant's gratitude to the Peruvian authorities for their assistance in brokering the agreement. And this is in R-171 and R-132. Claimant also highlighted the OGGS...
Counsel, on that point, I'm looking at R-132, and the gravamen of their press release was that they were happy because the blockade had been lifted. And of course it hadn't. So what do we make of that?
We will hear, Mr. President, that the blockade was lifted from the Paran sector, and there are internal communications that evidence the fact that there's a recognition that the Paran blockade was lifted through the Paran.
So they could go up the Paran Road, but
Yes,
not the Laxanga Road?
Correct. And in fact, we will also see that they couldn't even go up the Laxanga Road if they wanted because of the heavy rainfalls had damaged
I
the
know,
access
we're
road.
familiar with all that, okay. Thank you.
But unfortunately, after this agreement of February 2019 was signed, it became evident that the claimant and the Paran community had different interpretations of what they had agreed to, and each accused the other of breaching that agreement. Now, claimant seeks to portray the Paran community's interpretation as being preposterous or in bad faith, but it was not. Peru has demonstrated that the Paran community's interpretation was reasonable and consistent with the needs and expectations that that the community had expressed to claimant from the outset and repeatedly, which is, I want an access road through the Paran territory, and we will get to the topographical survey and what was behind that. And indeed, let's go there now. The agreement reflected two key demands of the community. One was that Invicta invest in a mine access road through the Paran territory, which, remember, it was something that the company had promised the Paran community early on, but later abandoned. And second, that a topographical survey be carried out, which the community believed would confirm that certain components of the mine were located within its territory. Now, claimant, on the other hand, argues that the text of the agreement provides that the Paran community would lift the blockade of the Laxanga access road. And perhaps this goes also to your question, Mr. President. While claimant wishes for this, the plain text of the agreement makes no explicit mention of access through Laxanga. In fact, Laxanga is not mentioned at all in that agreement. Paran is. The Paran access road is mentioned in that agreement.
Well, I take that point, Counsel, and I don't have the agreement in front of me, but there is also language to the effect that all coercive measures would be ended.
And
Is that relevant?
It is relevant, Mr. Chairman, in the sense that claimant has taken that phrase and has taken the phrase out of context to suggest that the agreement was to lift the blockade both from Paran and from Laxanga. Now, the reading of the community was that the lifting of the coercive measures would cover the Paran access road or access to the mine through the Paran access road, but not for the Laxanga. And the reason is evident. At that stage, they were also, at that moment, waiting for the topographical study to be conducted. And Paran felt that it was a compromise that had been reached, where they would cede by giving access through the Paran. Meanwhile, they would carry out the topographical study or survey on 20 March to determine how that road could be enhanced to provide a more permanent access to the mine.
Counsel, okay, you are interpreting from the standpoint of the Paran community. Now, does Peru have an interpretation of the agreement or not? Because Peru has adopted the interpretation of Paran. Is that right?
No, Mr. Garibaldi, we haven't adopted the interpretation of Paran in the sense that Peru is not a party to agreement. What we are saying is that the interpretation of the Paran community is not preposterous, is not in bad faith, which is claimant's position. We are saying that there's reasons in that agreement to believe that the community's interpretation of the agreement is reasonable from the perspective of the community and the history that had led to that agreement.
Now, let me ask you. The reference in the agreement to the medidas de fuerza, I think that is the term used. What does it refer to?
From the community's perspective is the lifting of access to the mine. From the community's perspective, that access to the mine has to be provided through the Paran.
Wait a second. There was no blockade on the Paran road.
There was no blockade through
There
the
was
Paran.
no blockade on the Paran road. The only blockade was the blockade on the Laxanga road. So the reference to lifting the medidas de fuerza was to what? In your interpretation, how do you see that?
My interpretation is to provide, the interpretation of the community that we argue is reasonable is to grant access to the mine, which is what the company wanted.
And where is what are the medidas de fuerza to be lifted?
Access to the mine.
Only from Paran.
Yes.
There was no medida de fuerza.
That was the interpretation of the
But
community.
but there was nothing. I mean, it's not a question of interpretation, it's a question of what are the facts. We cannot deal with interpretations, we have to deal with the facts, you see?
Mr. Garibaldi, there was no access to the mine at that moment because of the blockade on the Laxanga Road. The Paran community was saying you can access the mine and continue the work provided that you access the mine through the Paran, and we're facilitating that. We are allowing you to go through our territory into the mine.
And you have no opinion about that.
Again, I cannot speak in first person, the opinion of the Republic of Peru that it's a reasonable interpretation on the part of the community.
All right, thanks.
Now, going back to the issue, claimant does not dispute the fact that the community did in fact lift the blockade. The evidence shows that the company knew what it was agreeing to through the agreement, and that is in C-353, C-576, R-132. It agreed. The community did in fact lift the blockade through the Paran's territory and thus complied with the agreement from the interpretation of the community of what it had committed to under that agreement. Now, the second disagreement between the parties concerned the 26 February 2019 agreement provision for a topographical survey. The text of that agreement states that the Invicta Mining Company, together with the rural community of Paran, will identify and locate the affected land, the rural community of Paran, through a topographical survey, and such survey will take place on 20 March 2019, end of quote. Claimant contends in this arbitration that the purpose of that study or that survey was to assess alleged environmental damage to the Paran community's lands. The Paran community, by contrast, argued that the topographical study was meant to analyze whether any mine components were located on land that the community considered to be part of its territory, and for assessing necessary improvements to the access road to the mine. Now, this was consistent with the community's territorial claims and its desire to have a road through its territory to service the mine. And that evidence is on C-344, and I'll just say this quickly so that the transcript reflects it. C-344, C-213, C-264, and C-121. And the drafting history of the relevant provision of the agreement contradicts claimant's interpretation of environmental assessment being the scope or what had been agreed in February 2019, and that is reflected in C-344. And to be specific, an earlier version did reference OEFA and environmental assessment, but that was not agreed. It did not make it into the final version of the agreement because it was rejected, because that was not what the community meant when it said that it wanted a topographical survey. And so it is hardly surprising that the Paran community accused claimant of breaching that agreement when it later flatly refused the company to pay for the topographer. In any event, claimant's argument that an access road through Paran was off the table again exposes claimant's contradictory positions and the duplicity in engaging with the Paran community from the very beginning. Because as a reminder, claimant alleges that Invicta had remained open and interested in an alternative access road to the site through the Paran territory. But the Paran community refused to give claimant such an access road in earlier negotiations. And this is something that's addressed in Castañeda, paragraph 19. But in the reply, claimant alleges that it had had no use for the access road through Paran. So earlier saying access road, and now in the reply they're saying it had no use for access road through Paran, arguing that it was inadequate. But to its shareholders, claimant celebrated that it had gained partial access to the mine that was possible from Paran, Mr. Garibaldi, thanks to this February 2019 agreement that had just been reached by the parties. And this is in R-171. So the company was hailing that agreement as a way to gain partial access to the mine through Paran. And it was saying that to its shareholders. But claimant's conduct following the agreement's execution shows that it only saw such agreement as a means of lifting the blockade and no intention of following through its commitments. And true to form, claimant said one thing and then did another. But under such circumstances, it is impossible not to appreciate why the claimant felt cheated by claimant yet again. And you may disagree about the interpretation that the community had of the agreement, but we have to put ourselves in the shoes of the community and the discussions that had been had previously about access through Paran and what was signed on that day, which references only lifting of the blockade through the Paran community. Now, Mr. Garibaldi, you're a sophisticated lawyer. You have an interpretation of the agreement, but here we're talking about the Paran community negotiating what they thought was the first step in the resolution of the dispute. Remember, the 26 February 2018 agreement was the first step in a process of dialogue between the parties. It was called the Mesa de Diálogo, the negotiating table that it was formally launched that day through the efforts of the state to bring the parties together. And as a sign of good faith, that's where the community says, I will lift access to the mine through Paran. You conduct the topographical study. Again, it is not the permanent resolution of the dispute, but it's the first step to reaching that resolution of the dispute.
Council, we are scheduled for a break right about now. I don't know if this is a time that's convenient for you, or if not, can you identify a time in the near future? that would be
Mr.
good?
President, we will take the break whenever the tribunal tells us that the break is necessary.
Well, we're not that authoritarian, really.
We're happy to take the break now.
Okay, the schedule decrees a break right now, so let's do a 10-minute break, please.
Thank you.
Might as well ask that question.
Yeah, yeah.
All right, let's resume. Thank you all for being so punctual. We're being a bit compulsive about timing here today because for very, very good reasons. We're trying to keep these hearings from extending unduly into the evening. So forgive me if I seem a little bit compulsive, but we have a good reason for it. Louisa, can you give us a rundown of where we stand on respondents' use of time?
Yes, respondent has used 1 hour and 3 minutes of their time.
Okay, so they have essentially 2 hours to go. Okay, well, the tribunal will promise not to ask lengthy questions. All right, back to you.
Thank you, Mr. President. Can I have 1 minute to check what that means in terms of our planning?
Of course.
And because I understand that, Ms. Torres, that means that the responses given to the tribunal's questions are being deducted from our time?
That is the time already is your time that you've used. The time that you have invested in questions and answers to the tribunals is on a different clock. So the time
Okay.
already is your time.
Thank you. So if I can just have 1 minute, please. Okay, thank you, Mr. President. So let's move on to a different stage of the conflict. We've established that there was disagreement about the February 2019 agreement and its implementation, both parties accusing each other of not having complied with that agreement. And so this brings us to the 14 May 2019 incident where claimant took matters into its own hands, and this time with fatal consequences. Claimant does not dispute that it hired this obscure and inexperienced private security company, War Dogs, whose armed intervention produced a violent confrontation with the community on 14th May 2019, and that intervention tragically resulted in one fatality. Now, claimant desperately tries to downplay the actions of the War Dogs and the disastrous impact that it had on the dispute. Now, claimant asserts that the War Dogs peacefully entered the site. Now, that account is false, and it's directly contradicted by the contemporaneous police reports that indicate that 5 members of the Paran community were forcibly removed by the War Dogs. And that
Counsel, just to be clear, that document did not reflect firsthand observation by the police, but rather what they were told by the Paran community. Is that correct?
I believe that's correct because the police were not present at the
Right.
moment that.
So they were reporting what they were told in that document?
Yes, sir. And this is R262 in the record. But in claimant's own internal records further confirmed that it had actively sought out a powerful and intimidating security company well beyond any old, quote, regular security company, and this is R259. And that is precisely what it got when it hired the War Dogs. Now, claimant knows this, but is now embarrassed to admit it. It even refuses to call that outfit by its name, War Dogs, and instead it hides behind a bland acronym, WDS, I'm sorry. But they were War Dogs. They wanted a powerful security company, and that's what they got. And they entered the site, guns blazing, on 14th May 2019.
No, excuse me, your evidence for the proposition they entered the site guns blazing is what?
The police report saying that the War Dogs fired shots when they went into the property to remove those protesters.
Well, you'll give me the site to that because I don't remember having seen that exhibit.
Yes, we'll give you the site to the exhibit where, again, it's indicated that the War Dogs fired first not peacefully
Again,
enter
that's
the site.
reflecting what they were told by the Peron.
Yes, sir.
Okay.
So you accept the police weren't there?
The police were not there. The police were supposed to be there in coordination with the war dogs. And this is something that Mr. Bravo said in his witness statement. The police was going to accompany the security company going to the site, but the security company did not wait for the police. It went ahead without the police, resulting in that event. Now, you heard claimant's counsel today earlier say that the police wasn't there, but it was not because the police were not prepared to go. It's because the war dogs did not wait for the police to accompany them up to the site. There was a call that was placed by the war dog security to Mr. Bravo on that day, and Mr. Bravo asked, "Is the police with you?" And the security company said no. They said that they would follow, but we went ahead without them.
Counsel, it would seem from that we know that the police weren't there, but wouldn't be the only direct evidence that should come to us would be someone who was there. I mean, it's not much help saying that the police say that they were told no one was there. That doesn't establish it, does it? It's called hearsay in common law.
Correct, and it's the same hearsay that a claimant uses in respect of Mr. Retuerto, when they say that someone saw him being there and leading.
I mean, that must be right. It's not like a negative and negative makes a positive. It's two negatives and there's nothing there.
So claimant alleges that the entry of the war dogs to the mine on 14th May had been coordinated with the PNP. Again, this is what we are discussing. But again, we know that the war dogs entered the mine unilaterally without the PNP escort and without allowing the police to execute the operational plan that was prepared for that day. And those rash actions eroded that already frail relationship with the community. Now, the evidence that is described in detail in Peru's pleadings shows that from the start, the conflict with Paran community, claimant was never seriously about pursuing dialogue or a long-term agreement with the community. Because those efforts required both willingness and time, but claimant had neither, given that he cared only about meeting the ambitious PPF agreement repayment schedule, which we will come to. And the only real quick fix solution that claimant ever seriously considered was to lobby the Peruvian authorities to use force, no matter the cost or the risk to the human life, public safety, or even, and importantly, the long-term viability of a project that was openly rejected by the community that was in closest proximity to the mine. So let's turn now to that PPF agreement that was putting that time pressure on claimant that led it to simply seek that quick fix. And it's the PPF agreement that required claimant to begin commercial exploitation before December 2018. And thereafter, claimant owed PLA WADA the following repayments that you see. But claimant did not satisfy these commitments on the PPF agreement. And on 2nd July 2019, PLA accelerated claimant's PPF agreement obligations, citing 14 instances where claimant has defaulted. And due to such defaults, in August 2019, PLA initiated foreclosure proceedings to seize claimant's Invicta shares, which would be used to satisfy claimant's unpaid debt. And again, PLA seized those shares on 26 August 2019. Now, while claimant blames...
Please remind us, PLI is a mining company, right?
I believe that PLI is only a special vehicle for investing in the Invicta mine. PLI Wauda.
But it is in the mining business or in the banking business?
I will come back to that point. My understanding, Mr. Garibaldi, subject to confirmation, is that PLI was not in the mining business. It was not an active mining company. It's a special investment vehicle for the purpose of purchasing. And then Pandion owned the PLI, and then Pandion sold that.
To? to someone in the mining business or someone in the banking business?
I will come back to that question,
Thank you.
Mr. Garibaldi. The relationship, and this is again reflected in the pleadings. Lonely Mountain, Pandion, PLI. That was the chain that reached Invicta. But I'll come back to the question about the nature of Pandion and Lonely Mountain. And so the special purpose vehicle of Pandion, created to hold Pandion's interest, it's a PLI, and Lonely Mountain is a Peruvian mining company. Now so we know that claimant blames Peru for its loss, and the reality is that even in the absence of the alleged measures or emissions, claimant would not have reached commercial exploitation of the mine in time to meet its contractual obligations to PLI, and therefore would have lost its shares in any event. Now, this morning you heard claimant tell you that Lupaka had the permits. That was what they said. They had the permits, but that is not true. Contrary to what you heard, in its own submissions in this arbitration, claimant conceded, as it should, that it required additional permits to commercially exploit the mine. And instead of saying that it had all the permits, claimant argued that the missing permits could have been obtained in a matter of weeks. But claimant is incorrect. July 2020 is the earliest date by which claimant could have obtained the approvals needed to begin full commercial exploitation of the mine. And according to the legal mining expert, Ms. Mijanu Dufour, claimant needed to complete at least 4 additional regulatory steps before it could legally exploit the mine. Claimant needed to obtain authorization to purchase and store hydrocarbons at the Invicta mine. It needed an environmental certification of an alternative water management system. It needed a minimum authorization to begin commercial exploitation, and it needed licenses to use water from sources not contemplated in claimant's 2009 EIA, Environmental Impact Assessment. Now, Ms. Dufour is the only independent legal mining expert in this arbitration, and she will address each of these issues or requirements in more detail during her presentation. Now, claimant has incorrectly suggested in its skeleton, and again today, that Peru's assertions based on Ms. Dufour's conclusion represents new arguments. But claimant first alleged that this mine was on the, and I quote, cusp of the exploitation stage at paragraph 5 of the memorial. Now, Peru responded in subsection 2F1 of the counter memorial, citing evidence that the mine could not have begun exploitation before claimant's PPF agreement obligations began. Claimant then reintroduced a new mining expert report in the reply with Micon, which expounded claimant's position on the Invicta mine's permitting status. Now, I can, Mr. Chairman, respond to the question about some of the permits that addressed and the sequence. I am concerned about the time. I'm happy to go through that table now, and I would seek the tribunal's indulgence if this can be treated as part of a response to the question that you asked earlier.
I think our own time is about elapsed, so perhaps you should just drive on.
Okay. Can we come back to this point? Because it seems, Mr. Chairman, based on the question, that there is a concern on the part of the tribunal about the basis for us saying that we are responding to claimants' arguments and submissions in the reply with Ms. Dufour's expert report. If you're satisfied that we have done so, we can move on. If not,
I can't tell you we're satisfied. We haven't really had opportunity to deliberate on this question. But if we feel we need to hear more, we'll get back to you.
thank you very much, Mr. President. And therefore, I will not address the table, but I will just make an observation based on what we heard today and the request that claimant has made. Now, again, Peru engaged Ms. Dufour to evaluate the conclusions of that new evidence submitted by claimant in the reply. Ms. Dufour also addressed the issue of social license, as you know, as part of her report, based on her ample experience in the mining sector in representation of mining companies. And surely claimant cannot argue that that is social license is a new argument. It was one of the central arguments raised by Peru, including on the basis of other expert evidence. But yet, claimant has doubled down in the reply on its argument that doubled down on its argument in the counter memorial, saying that the social license is a hollow defense, were the words that were used today by claimant's counsel. But yet, claimant is now asking you, for the first time this morning, to make an interim ruling to disregard Ms. Dufour's expert testimony. And Peru has objected to that request. It's baseless. There's no procedural rule why the expert evidence submitted by Ms. Dufour should be disregarded. But second, claimant request is improper and untimely. Claimant has had Ms. Dufour's report since 25 January 2023, and yet it has chosen to ambush Peru and this tribunal by making that request today. And claimant's counsel unwittingly revealed why they have made that request. It stated that they would consider, or they would decline to cross-examine Ms. Dufour if the tribunal grants claimant's request. Claimant doesn't want you to hear from Ms. Dufour. And that's why it's asking you to disregard that expert evidence, because it knows that it's fatal to its case on causation. But as I stated, Peru firmly objects to claimant's request. And in any event, if the tribunal is prepared to even entertain claimant's extemporaneous request, Peru requested the Micon report, which was introduced in the reply.
And counsel, perhaps this isn't really the time to argue this issue. I mean, our concern is just whether what's being done here is consistent with procedural order number 1, 14.4, where we say in the second rounds of submission, the parties will limit themselves to responding to facts and legal arguments made in the first round, and whether we're falling within that ambit. But I don't think it's really a good investment of anybody's time for us to argue the issue now on the basis of the position we've got now.
Understood. Thank you, Mr. Chairman, for that guidance. If the tribunal desires, we can then make submissions at that point in the procedural order, but we will move on pursuant to your instructions, Mr. President. So in addition to the above permits, claimant needed to secure a reliable ore processing plant capacity to meet its repayment obligations. But as of October 2018, claimant did not have such capacity, either at off-site plants or at the plant operated by claimant. Now, claimant witnesses, including Mr. Castañeda, acknowledged that the 3 plants at which claimant conducted pre-production testing provided it with, and I quote, unsatisfactory results and experiences. This is Castañeda, first witness statement, paragraph 89. Now, the processing plants lacked the capacity to meet claimant's needs, were unreliable, and or lacked the permit needed to lawfully process ore. I'm coming to the end of my presentation, Mr. President. My portion. Now, in October 2018, Will Ansley, claimant CEO, summarized the impact of these issues to claimant's co-founder Gordon Ellis, present in the room, saying or declaring that, and I quote, as a result of milling being insignificantly behind the mine development, I have suspended all development activities and sent the contractors away, end of quote. This is exhibit MI 7.
Can you remind us of the date of that?
I will in a minute, Mr. Griffith.
You say October 2018?
19 October 2018, Mr. Griffith. So these issues were not, as claimant now argues, and I quote, easy to remedy, end of quote. Now, claimant also asserts that its acquisition of the Malay plant would have enabled it to meet its commitments to PLI. That too is incorrect, and Ms. Dufour will explain in her presentation that even if claimant had executed the draft agreement with PLI and closed on the Malay plant transaction with Buenaventura, which it did not, significant time was needed before ore processing could begin at such a plant. And so Ms. Dufour demonstrates that claimant could not have begun such processing before July 2020, which would have been way past the commercial exploitation deadline of December 2018, under the PPF agreement, and even claimant's most optimistic prediction of its PPF agreement delivery schedule of January 2020. I will, in the interest of time, move forward and skip certain parts. Mr. President, with your indulgence, I will now cede the floor to Mr. Tim Smythe, who will recall Peru's jurisdictional objections and then issues on attribution. I thank you for your patience, and unfortunately, you will hear again from me later on in this presentation. Thank you.
Thank you. Mr. Smythe.
Thank you, Mr. President. Good afternoon, Mr. President and members of the Tribunal. My name is Tim Smythe, and I will be addressing Peru's jurisdictional objections in this case, as well as the attribution issues. Now, Peru has demonstrated in its pleadings that the Tribunal lacks jurisdiction to hear claimant's claims for two reasons. The first reason is that claimant disposed of its investment, along with its right to bring a treaty claim, prior to instituting proceedings. It did so when it transferred its shares in Invicta to PLI Huara on 26th of August 2019. Consequently, the Tribunal lacks jurisdiction ratione personae. The second reason is that claimant has failed to provide a waiver on behalf of Invicta, the enterprise to whom its claims relate, as was required under the treaty. As a result, the Tribunal lacks jurisdiction ratione voluntatis. Starting with the first objection, I'll begin by summarizing the applicable legal principles. The relevant jurisprudence, including that of the International Court of Justice, instructs that the critical date for assessing the Tribunal's jurisdiction is when proceedings were instituted. This is confirmed, for example, in the arrest warrant case, in the extract that appears on the slide. And that's RLA 159, paragraph 26. Second, there is a general rule that an investor must hold a qualifying investment at the time proceedings are instituted, otherwise the Tribunal will lack jurisdiction. This was confirmed by the Tribunal in the case of Avon against Costa Rica, a case which is directly on point for two reasons. First, the claimant in that case had disposed of certain investments prior to instituting proceedings. And second, the treaty in that case, the DR CAFTA, has almost identical definitions of investor and investment to the treaty in this case.
Counsel, let me, I promised not to ask questions. I read Avon, and I was struck that the language they used to describe the circumstances that might justify the exception was a little broader than has been used in some settings here. It was not confined to actions by the state. It suggested that actions by third parties might be sufficient. And they quoted a celebrated case, which doesn't seem to be of record here, that would seem to support that proposition. I wonder if you have a thought on that.
Sure, Mr. President. The Avon Tribunal indeed did refer to the Mondev case, which I think is the one that you're referring to. And the Tribunal distinguished that case on the basis that in the Avon case there was no direct causation between the actions of the state and the loss of, and the disposal of the claimant's investment. Whereas in that case, while it's correct that they refer to third parties in one of the paragraphs, if you look more closely, the basis of the distinction is this issue of direct causation between state actions and the disposal of the investment. And actually the Tribunal notes that in the Mondev case, the disposal of the investment resulted from a foreclosure on the part of the city of Boston, which of course would be a local municipality or state agency. Thank you. So the Avon Tribunal examined the relevant case law and concluded that there was, quote, a general rule that an investor must own the investment at the date of the notice of arbitration to benefit from treaty protection. And that's RLA 17, paragraph 298. And the justification for that general rule is quite simple.
Counsel, I wonder if it would be acceptable to the parties to put Mondev into the record. Would that be agreeable?
Sure.
We don't need to have yet another drive, but in due course, if you could put that in, please.
Yeah, of course, Mr. President. I'm sure that won't be a problem. But standing back for a second to focus on the justification for this general rule that was expressed by the Avon Tribunal, it's really that it avoids a state facing a proliferation of claims from successive owners of an investment. And now, moving on, the general rule elucidated by the Avon Tribunal is subject to only two exceptions, which also emerge from the case law. The first is where an investor retains the right to bring a claim against the state in the contract through which it disposes of the investment. This was the case, for example, in the cases of National Grid against Argentina and Gemplus against Mexico, which are on the record as RLA 12 and RLA 18. The second exception was directly referenced by the Avon Tribunal, and this is what we were referring to in our discussion just now, which is where special circumstances are present. And as I said, if you take a close reading of the Avon Tribunal's ruling, it's clear that the tribunal was talking about direct causation between the state's actions and the loss of the investment. And I'd refer the tribunal to RLA 17, paragraphs 299 and 301. When those principles are applied to the facts of this case, the conclusion that must be drawn is that this tribunal lacks jurisdiction. There is no dispute that the proceedings were instituted on 30th of October 2020, when ICSID registered claimants' requests for arbitration. There is also no dispute that the disposal of claimants' shares in Invicta was prior to that, on 26th of August 2019, and so the general rule in Avon applies. The facts likewise show that neither of the two exceptions to that general rule apply. So turning to the first exception, it is an undisputed fact that claimant transferred its shares to PLI Huara under the share allocation agreement, and that's on the record as Exhibit R193. And there is no provision in that agreement retaining claimant's right to bring a claim in relation to the Invicta project. Far from it. The share allocation agreement actually disposes of those same rights. Clause 2.2 of that agreement provided that Andean American, the subsidiary through which claimant held its shares in Invicta, transferred not only its shares in Invicta, but also a broad, unlimited suite of matters and rights comprising, quote, all matters of fact or of law pertaining to the encumbered shares, i.e. the shares in Invicta, without reservation or limitation, and these included, but were not limited to, all economic ownership and information rights related to the encumbered shares without limitation of any nature. And that's at clause 2.2 of Exhibit R193. The rights, sorry, please.
Excuse me. Is that an outright transfer or a pledge?
That's in the share allocation agreement, but there is similar language in the pledge agreement, which shows that the wording isn't exactly the same, but a similar suite of rights was pledged to PLI Huara under the pledge agreement.
Can you give me the reference in the record to both agreements?
Share allocation agreement is R193. And if you'll indulge me with one minute, I should be able to find the reference for the other.
Mr. Smythe, because of the time, perhaps you could provide it after the
Understood.
proceedings.
And, apologies for the slow
that's fine.
retrieval of the reference.
Get it to us later.
One of my colleagues has piped up and told me it's R97.
Mr. Smythe, this is tribunal time, but I'm just trying to follow your argument about the exceptions. Is it basically the case that if the claimant makes out its case on causation, then at the same time it would come within the second exception, and if it's unsuccessful on that, it would seem it might fall on the second exception as well? So is it chicken and egg somewhat, that if the claimant is right on its case on its merits, it would seem to overcome the exceptions? If it fails on the merits, it will fail on the exception as well.
Yeah, I understand the question. So that there is some overlap between the jurisdictional and merits issues when it comes to this particular type of objection.
So I'm just trying to sort out the logic order. If there's two hurdles, and it falls on the first on jurisdiction, you don't have to go to the second, but perhaps we can't see clearing the first hurdle until we answer the second one.
As I say, there's certainly overlap, but it's not. There's sort of if you play out the consequences of a finding of the tribunal that there was no deprivation or no direct causation, that would lead to a lack of jurisdiction, of course. And then the same is true, obviously, the tribunal could dismiss the expropriation claims on the same basis, because that's an element of the expropriation.
It sounds like basically you're either clear both hurdles or you're clear neither.
It's sort of an all or nothing situation. So if the tribunal finds there's no direct causation, it lacks jurisdiction, it would also lead to the dismissal of the expropriation claims. The claims that do not require direct causation, which would probably potentially include FET and FPS, would perhaps fall into a different category. But I will proceed unless you had further questions on that point. So turning to the second exception, which I think we've already discussed to some extent, so perhaps we can go through it quite quickly. Peru has demonstrated that there is no direct causation between actions of Peru and the loss of the investment. Instead, such loss resulted from claimant's own actions, both in failing to achieve amicable community relations and in entering into overly ambitious repayment terms under the PPF agreement that it could not meet, and would not have met even in the absence of local opposition from the Peruvian community. Claimant has not substantively challenged the existence of the above general rule, or the two exceptions that I have mentioned. Nor has claimant cited any case law, examined the share allocation agreement, or indeed the pledge agreement, or refuted Peru's interpretation of those agreements. Instead, claimant focuses on the definition of an investor under Treaty Article 847, which includes, I quote, a national or an enterprise of Canada that seeks to make, is making, or has made an investment, and claimant argues that the words has made in such definition demonstrate that the definition encompasses an investor who no longer holds their investment. But that treaty language actually supports Peru's position, not claimant's. Now, I don't want to give the tribunal too much of a grammar lesson here, but the text uses the present perfect has made. It thus refers to an investment that was made in the past, but has continued through to the present time. And this is confirmed by Sidney Greenbaum's seminal work on English grammar, which notes that, quote, the state present perfect refers to a state that began before the present time of speaking or writing and continues until that time, perhaps including it. And that's at RLA 170, page 270.
Council, is that the equivalent of past pluperfect and future imperfect?
Pluperfect is had, right? So that's so the past perfect would be I had an investment, whereas this is sort of I have an investment, or I have made an investment. Had made would be the past perfect.
Isn't there one of the things, I learned English as a second language, but one of the things I learned from good teachers is that the present perfect can refer also to actions that happened in the past but that have an importance in the present. So is that something that Greenbaum refers to and is not quoted here, or not?
I mean, I'd have to look in detail at the page from the grammar in question, but as I recall, the examples that are used by Greenbaum focus on an action that has started in the past and continues through to the present. So to take an example, if I say, I have bought a house in Washington, D.C., it means I still own that house, right? Whereas if I say if I just use the simple past, I bought a house in Washington.
But if I tell, that's right, that's correct usage. Yes. But if I tell you I have studied Latin, it doesn't mean that I'm still studying Latin. It means that I have studied it in the past and it is relevant to the present.
But it has to have some connection through to the present. So you've studied Latin and you still retain that knowledge from your studies, I think is how I would look at it. But also I think the primary use of the present perfect would be an action that started in the past and continues through to the present. And if
I-
the parties, if I could just add one thing, if the parties had wanted to make it clear that it included a completed action, they could have just used the simple past. They could have just said an investor who made an investment. They wouldn't have used the present perfect. There would have been no purpose.
I think that we should not debate this later.
Understood. Thank you, Mr. Garibaldi. So I think in the interest of time, I will conclude on that first objection and move to the second, just very briefly, which is based on Article 823.1e of the treaty, which requires that where a claim is brought with respect to an interest in an enterprise that is owned by a claimant, then a waiver must be provided not just on behalf of the claimant, but also on behalf of that enterprise. And there is no dispute that claimant failed to provide that waiver in this case. The claimant instead relies on an exception under Article 823.5, which provides that there is no waiver requirement where the state has deprived the investor of the relevant enterprise. And so this exception, the reliance on this exception fails for quite similar reasons to those discussed in the first jurisdictional objection. Namely, Peru has not deprived claimant of its investment. Rather, claimant lost its investment as a result of its own failings and contractual breach. Accordingly, due to claimant's failure to provide a waiver from Invicta, the tribunal lacks jurisdiction to hear claimant's claims. And so unless the tribunal has any further questions, I will now move to the attribution issues. Yes, and if I could just refer the tribunal in response to Mr. Griffith's question, that in the rejoinder at paragraph 474, we addressed this issue of the overlapping jurisdictional and merits issues and the consequences of that.
Thank you.
So turning to the attribution issues, claimant has argued in this arbitration that the actions of the Peran community are attributable to Peru under customary international law. Before moving to the specifics of claimant's arguments, there are two important threshold considerations that bear emphasis at the outset. The first is the outlandish and unprecedented nature of the proposition that claimant advances, that the actions of a rural or indigenous community should be attributable to a state under public international law. Claimant had two opportunities, in its memorial and its reply, to provide precedent to support its hypothesis on attribution, but it did not do so. The reason for this is simple. There is no such precedent. In fact, the only comparable findings of investment tribunals indicate rural and indigenous communities cannot be assimilated with the state. In Bear Creek against Peru, for example, a case under the same treaty as the present one, and also involving the actions of rural communities, the tribunal distinguished between the actions of such communities and the state. It noted that, quote, the indigenous communities, irrespective whether they were in favour of or against the project, are not respondent party in this arbitration. Rather, the state of Peru and its government are respondent, and it is their conduct which the tribunal has to decide upon. And that is at CLA 86, paragraph 666. Peru submits that exactly the same conclusions should apply in this case in relation to that issue. The second overarching point is that, were claimant's argument to be upheld, this would have far-reaching consequences for the international community. States all over the world would be deemed responsible and potentially liable under international law for any actions of rural communities deemed to have damaged foreign investors. Not only that, but as we shall see, claimant's arguments are based on the very same legal instruments that Peru has put into effect in order to respect the rights, autonomy, and traditions of rural communities. If a state were to be held liable as a result of such instruments, this would provide a powerful incentive to cease recognizing rural and indigenous rights. So moving now to the specific arguments, claimant bases its attribution theory on ILC Articles 4, 5, and 7. But none of the principles of customary international law enshrined in those articles supports claimant's contention. I'll address each in turn. Claimant argued for the first time in its reply that the Peruvian community's actions are attributable to Peru under ILC Article 4. This article embodies what is often referred to as the structural test for attribution. We have shown the wording of this article on the slide. For the sake of brevity, I won't read it, but this article connotes two requirements. First, that the entity is an organ, and second, as the commentaries to the ILC articles confirm, that the actions in question were carried out in an official capacity, and that's at CLA 18, page 41, paragraph 7. Neither requirement is met in respect of the Peruvian community. Regarding the first requirement, claimant latches on to the final part of subparagraph 1 of Article 4 to argue that rural communities are territorial units of the Peruvian state. But that argument is simply wrong. The concept of a territorial unit under international law refers to the political subdivisions of a state. In other words, the constituent provincial, regional, or geographical administrations of which a state is comprised. Indeed, all of the cases cited in the ILC commentaries in relation to territorial units, which we've listed on the slide, relate to such decentralized administrations. That's at CLA 18, page 41, paragraph 9. Rural communities in Peru, which are communal organizations with separate legal personality from the state, do not fall within this category. And Peruvian law does not support claimant's proposition. This is important. As confirmed by the tribunal in Yandanol against Egypt, quote, to determine whether an entity is a state organ, one must first look to domestic law. That's at RLA 25, paragraph 160. Rural communities under Peruvian law are not included within the structure of the state under Title 4 of the Constitution, and that's important given that Article 4 is the structural test for attribution. Nor are they included under Chapter 14 of the Constitution, which relates to decentralized regions and municipalities. And this really puts paid to claimant's argument, which it repeated in the presentation this morning, that the Peruvian community is a municipality. Rural communities are simply not included in any of those provisions, which you can find at Exhibit C23, Articles 189 to 199. And even if claimant had established that the Peruvian community was a territorial unit, and therefore an organ of Peru, it would still have failed to establish that the actions of the community were carried out in an official capacity. Claimant has thus failed to meet the second requirement of ILC Article 4. In fact, claimant has not even tried to demonstrate that the Peruvian community as a whole acted in an official capacity. In any event, the facts and evidence demonstrate otherwise. And, notably, at the time, claimant never believed that the Peruvian community acted in an official capacity. I will come back to this point when addressing ILC Article 7. Now, importantly, claimant has not cited a single legal authority that even remotely supports its contention that rural communities in Peru should be treated as an organ of the Peruvian state. The fact is that not a single legal source or lawyer would seriously argue that rural communities in Peru are organs of the state. And this explains why claimant did not submit an independent expert opinion in support of his attribution theory. It is also telling that claimant decided not to call Mr. Vela, the independent legal expert offered by Peru, who in his expert report addressed the standing of rural communities in Peru. Unfortunately, I didn't have time to create an empty chair slide for Mr. Vela, but we can imagine it. So I move now to ILC Article 5. There are two requirements under this principle of attribution. First, the relevant person or entity must be, quote, empowered by the law of that state to exercise elements of the governmental authority. And second, as with Article 4, the person or entity must be, quote, acting in that capacity in the particular instance. Regarding the first requirement, the ILC commentaries emphasize that the analysis, quote, depends on the particular society, its history and traditions, which in this case would include the historical existence of indigenous and rural communities since pre-colonial times in Peru. The commentaries also set out the following 4 non-exhaustive factors to consider: the content of the relevant powers, the manner of their conferral, the purpose of the conferral, and the level of accountability the personal entity has to the state. And you can find this at CLA 18, page 43, paragraph 6. Now, in claimant's presentation earlier, you heard a lot about the Rondas Campesinas, on whom claimant's ILC article arguments focus almost exclusively. Contrary to claimant's arguments, the Rondas Campesinas are not empowered with governmental authority. Under Peruvian law, rural communities have the right to establish Rondas Campesinas to exercise those communities' traditional rights of self-defense over their territory and property, and also cooperate with the authorities of the Peruvian government where necessary. And this much is clear from the law on the Rondas Campesinas, which is at Exhibit R116, Article 1. Applying the 4 factors I just mentioned to the Rondas Campesinas, all of these weigh against attribution in the instant case. First, regarding the content of the relevant powers, claimant makes much of the fact that the Rondas Campesinas exercise certain conciliation functions pursuant to Article 149 of the Constitution and related laws. And you can find that article at Exhibit C23, Article 149. However, such functions are not governmental in nature. Article 1 of the Rural Patrols Law expressly states that Rondas Campesinas carry out extrajudicial conciliation functions. That's Exhibit R116, Article 1. The Rondas only have power to apply customary law of rural communities, not Peruvian law, and that's at Exhibit C23, Article 149. The right to establish Rondas Campesinas does not reflect an extension of state power. As the Supreme Court has confirmed in its decision of 3rd November 2009, which claimant also cited this morning, they, quote, constitute a form of communal authority in the places or rural areas of the country where they exist. And that's at Exhibit C599, page 4, paragraph 7. That's communal authority, not state authority. Regarding the second factor, the manner of conferral, such powers are not conferred as such. Rather, they constitute a recognition of the inherent and historical rights and prerogatives of rural communities. And this was again confirmed by the Supreme Court in its decision. That's at Exhibit 599, page 5, paragraph 7. Similarly, in relation to the third factor, the purpose of the relevant powers is not to further the exercise or extend the reach of the state, but to recognize the inherent rights of rural communities. This is consistent with various international law instruments regarding the recognition of indigenous rights, such as the ILO Convention 169, to which Peru is a party. Article 2.2b of that convention provides that states must take measures for promoting the full realization of the social, economic, and cultural rights of these peoples with respect for their social and cultural identity, their customs and traditions, and their institutions. And that's at RLA 28, Article 2.2b. Now, claimant mentioned in passing during its presentation this morning a MINEM determination that the Peruvian community did not meet the requirements for qualifying as an indigenous people for the purposes of the prior consultation requirement under Law 29785. And that was the law that looked to implement that same prior consultation requirement under ILO Convention 169. And really this is a red herring in our submission. It doesn't change the fact that rural communities can be considered to be indigenous people under Peruvian law, and the fact that really, when you take a step back, their legal status and the protections afforded to them and their treatment under Peruvian law is analogous to indigenous communities, regardless of the precise modalities that were cited in the document cited by claimant this morning. So the international conventions that Peru has cited in its submissions continue to be relevant for the tribunal's consideration. With respect to the last factor, namely the level of accountability, pursuant to Article 89 of the Peruvian Constitution, the rural communities are autonomous in their organisation. In fact, much like indigenous communities as they're defined under international law. In fact, as Professor Maney confirms in his unchallenged testimony, empty chair slide again, were Peru to interfere with rural communities' internal affairs, the state could face liability. And that's at the Maney report, paragraph 50. Oddly, claimant seems to dismiss the relevance of this evidence, despite accepting the fact that accountability is indeed one of the factors for consideration under ILC Article 5. Now, even if the Rondas Campesinas were imbued with governmental authority, which is not the case, claimant has not satisfied the second limb of the test, namely that the relevant acts were carried out in exercise of governmental authority. Claimant has not satisfied that criterion. Claimant again relies heavily on the conciliatory role or jurisdictional function of the Rondas Campesinas under Article 149 of the Constitution. However, a closer look at that rule, at the role under that article, is strictly limited by subject matter and territorial scope. Article 149 provides that, quote, the authorities of the rural and native communities, with the support of the rural patrols, that's the Rondas Campesinas, may exercise jurisdictional functions within their territorial scope in accordance with customary law, provided that they do not violate the fundamental rights of the individual. And that's C23, Article 149. So this provision implies at least three limitations on the powers of Rondas Campesinas. The relevant functions must be exercised 1, in the rural community's territory, 2, in accordance with customary law, and 3, in conformity with fundamental rights. Supreme Decree number 25 of 2003 then imposes a further limit on the disputes in relation to which Rondas Campesinas may act as conciliators. Those disputes are limited to only disputes related to the possession, usufruct of communal property, and the use of different communal resources, and that's at R103, Article 13. The actions of which claimant complains, the forcible entry to a mine site, detention of individuals, destruction of property, and obstruction of an access road, fall well outside the scope of those limits. Claimant itself stresses that such actions took place outside community territory, including in its presentation this morning, where they said, and I quote, Paran were on Laksanga's land continuously. Such actions did not concern usufruct or communal property and would have violated any one of a number of several fundamental rights, including the right to physical integrity, property, liberty, and security of the person. Again, that's from the Constitution, Exhibit C23, Article 2. The actions of the Paran community, ultimately, were the actions of private individuals acting in a private capacity. The principle of attribution under ILC Article 5 is therefore simply not met. Lastly, claimant belatedly relied on ILC Article 7 in its reply, which provides that the conduct of an organ of a state or of a person or entity empowered to exercise elements of the governmental authority shall be considered an act of the state under international law if the organ, person, or entity acts in that capacity, even if it exceeds its authority or contravenes instructions. Confusingly, claimants seem to allege at its skeleton at paragraph 77, and indeed in its presentation this morning, that this article provides a separate ground of attribution to ILC Articles 4 and 5. That is not the case. The wording of the article plainly references ILC Articles 4 and 5, and it still requires that the relevant person or entity acts in an official capacity. However, the article simply clarifies that those acts will not per se fall outside such capacity just because they are ultra vires. The key issue here that claimant still fails to grasp is that for Article 7 to apply, the relevant acts must be carried out in exercise of ostensible authority, that is, under cloak of authority. As Judge Crawford explains, quote, "A state is not responsible for every act done by an individual in its service, but only when the individual purports to act on behalf of the state." And that's RLA 24, page 137. There is therefore a distinction between, on the one hand, official but ultra vires acts, which are attributable, and on the other hand, acts that are not carried out in exercise of any ostensible authority, which are not attributable. And there's a consistent line of jurisprudence to this effect, which was cited by Peru in its pleadings, and I would respectfully refer the tribunal to the discussion of such jurisprudence at paragraphs 461 to 466 of Peru's counter memorial and the cases of Malen, Kaya, and Jaeger addressed therein, which are at RLA 31, 32, and 33. And just briefly on an issue that the claimant referred to this morning in its presentation, which was the use of weapons by the Peruvian community that were allegedly provided by the Peruvian state in the context of combating terrorism. Just one point that I'll highlight in relation to this for the purpose of attribution is that there's never been a suggestion at any point that those weapons were used for the purpose for which they were provided, which ultimately was historical around 30 years ago and is effectively obsolete. So even if you got to the point where you consider that the provision of those weapons is some sort of conferral of state authority, it has no relevance for it has no bearing on the ultimate conclusion in relation to attribution. Claimant has provided no credible evidence that the Peruvian community was acting or even purporting to act in exercise of official authority. In fact, claimant's position is belied by its own contemporaneous correspondence, which shows that it did not consider that the Peruvian community or its Ronda Campesina were organs, or that they were empowered with governmental authority, or that they were acting in an official capacity. In fact, in a letter to Minem dated 6th February 2019, claimant described the Peruvian community members as, and I quote, terrorists. That's at Exhibit C15, page 2. So classic non-state actors. And in all of its contemporaneous discussions with state organs, including Minem, claimant not once argued or even suggested that the Peruvian community had exercised elements of governmental authority. Moreover, in its letter to its creditor, PLI Huara, dated 19th of August 2019, claimant argued that a provision in the PPF agreement obliged PLI Huara to negotiate to resolve repayment obligations in the event of force majeure or an act of state. And that's at R218, page 3. Had claimant genuinely believed that the actions of the Peruvian community were imbued with official authority, it surely would have relied on such wording in relation to act of state to argue that these actions qualified as an act of state. However, it did not, and instead argued that such actions constituted continuing force majeure. And the inconsistencies that I've just identified really are emblematic of claimant's attribution arguments in general. Such arguments ignore the legal standard, are formulated on the hoof out of expediency, and are entirely contradicted by the evidence. The tribunal should therefore have no difficulty dismissing them and concluding that the actions of the Peruvian community are not attributable to Peru under international law. And with that, I pass to my colleague, Patricia Granay-Lebat, to discuss claimant's merits claims.
Mr. President, should we proceed, or is this time for a break? We're in your hands.
Let's do 5 minutes.
And before we break, may we ask Ms. Torres to give us update on time?
You are up to 1 hour and 48 minutes.
Thank you.
All right, I admonish you to be back in 5. thank you all for being so prompt while the tribunal reconstitutes itself. Are respondents ready to resume? Okay. Reporters, are we okay? Okay. The secretary has taken her seat. Yeah. All right. 1 minute and, an hour and 12 minutes remaining. Is that right?
Yes, sir.
Okay. All right. To the respondent.
Thank you, Mr. President. I will now address the three substantive claims raised by claimant under the treaty. And I begin by noting that for the most part, there is no disagreement between the parties concerning the applicable legal standard under the treaty. However, claimant fails to apply those standards to the facts. And claimant's briefs are mostly devoted to presenting a self-serving and partial account of the facts and then slapping a label on such facts. And it did the same thing this morning. And it is telling that this morning claimant spent 5 minutes of its 3-hour-long presentation addressing the merits. And I had to check that fact with my team. And it did so because when the facts are properly assessed under the relevant and well-established legal standards, the conclusion is that Peru did not breach its obligations under international law. And I will begin by addressing the first and the main claim advanced by claimant concerning full protection and security. Now, Article 805 of the treaty provides that each party shall accord covered investment treatment in accordance with the customary international law minimum standard of treatment of aliens, including full protection and security. And then that same provision further specifies that the concept of FPS and FET does not require treatment in addition to or beyond that which is required by customary international law minimum standard of treatment. Now, claimant acknowledges, as it must, that the applicable standard of FPS is that under customary international law MST. Now, the parties are also in agreement that the FPS standard requires a host state to exercise reasonable due diligence. And you have the quotes and you find the sources for all of these in reply 626 to 627 and then 682. Now, the parties also are in agreement that that FPS standard does not impose strict liability on the host state to prevent physical or legal infringement of the investment or provide any guarantee or warranty. And in general terms, claimant also agrees with Peru that the state is expected to take, and I quote, such measures to protect the foreign investment as are reasonable under the circumstances. And also that the tribunal, and I quote, must take into account the circumstances of the particular case. And finally, that the FPS standard is an objective one that does not vary from state to state or investor to investor. Now, despite claimant agreeing that the reasonability of the state's measures to protect investment must take into account circumstances of the case, claimant incorrectly argues that any consideration of the particular circumstances of the case would render the FPS obligation less objective and therefore inappropriate. But claimant's position is inconsistent with the case law. The jurisprudence, some of which is accepted by claimant itself, demonstrate the following points. One, that the FPS obligation under customary international law is an obligation of means rather than of results. Now, claimant concedes this point in its reply, paragraph 626, but fails to respect it. Claimant also recognizes that the state undertook affirmative steps to protect the investment, but nonetheless demands compensation because such steps did not achieve claimant's desired result of quashing the Peruvian community's opposition to the Invicta project. The jurisprudence also demonstrates that the due diligence standard requires a state to take such measures to protect the foreign investment as are reasonable, again, under the circumstances. And claimant concedes this point in reply, paragraph 626, but argues that Peru's decision not to use force against the rural community when claimant demanded it was unreasonable. And it is established by case law, including by the tribunal in Strabag v. Libya, that the FPS duty of due diligence cannot be viewed in the abstract and in isolation from the conditions prevailing in the host state. This is RLA 84, in paragraph 234. Thus, and contrary to claimant's argument, in assessing claimant's claim of violation by Peru of the FPS obligation, the tribunal is indeed required to consider whether the state's conduct was reasonable under the relevant circumstances and conditions prevailing in this particular case. Now, the legal authorities cited by the parties recognize that the circumstances found to have been relevant include, inter alia, the general situation within the state. That's CLA, an authority submitted by claimant 25, paragraph 406. The state's development means and resources, also circumstances relevant. Same authority, CLA 25. And the existence of civil strife, RLA 8, paragraph 310. Now, Peru explained in the counter memorial and again in the rejoinder that the circumstances given rise to and surrounding the conflict included the following. Both within and outside of Peru, there is a long history of social conflict between mining companies and local communities. These conflicts are multidimensional because they implicate a balancing of rights that the state must carefully manage between the territorial and human rights of certain, between the territories and the human rights of certain protected communities and the rights of investors. Both within and outside of Peru, free and democratic societies permits the use of force by law enforcement, but only under limited and exceptional circumstances. And the competent authority bears ultimate responsibility and discretion to decide if, when, and how to deploy those resources, mindful of the potential consequences of doing so. Both within and outside of Peru, law enforcement agencies are not designed or equipped to serve as private security forces for companies and their investments. When force has been used by state actors in the context of social conflicts, it has proved counterproductive to long-term solutions in this context of social conflict between mining companies and rural communities. And notably, claimant distorts not for the first time Peru's explanation and ignores many of these circumstances, dismissing them as aggravating factors or excuses and therefore not relevant. That's what they said in the skeleton pre-hearing brief in paragraphs 98 to 99. Now, like many other democratic states, with this history of social conflict with rural and indigenous communities in the extractive sector, Peru developed a legal and policy framework that reflects both international treaty law and the protected status of certain communities, established corporate social responsibility norms, ESG standards, and industry-imposed practices. The law and policy of other democratic states, including Canada, which directly assisted Peru in developing the applicable framework for both prevention and management of social conflict, and the lessons learned from Peru's own history of social conflict in the mining sector. Now, on the whole, Peru's legal framework and institutions aim to ensure the active and constructive participation of local communities, encouraging mining companies to obtain the acceptance of their mining projects by local communities, and promote dialogue as the best means of resolving any disputes that may arise with a view to obtaining a long-lasting, durable, sustainable resolution to that conflict. And all of what I have mentioned are circumstances that must be taken into consideration when assessing Peru's conduct in the present case. Now, the tribunal will recall that claimant began this arbitration alleging that Peru took no action, and I quote, in relation to claimant's social conflict with the Paran community. In the counter memorial, Peru provided a detailed account of Peru's, and can we go back one slide, please? Thank you. So these are some examples of claimant arguing in its memorial that Peru took no action. But in the counter memorial, Peru provided a detailed account of Peru's consistent, affirmative, and multi-pronged effort throughout the course of the conflict to help claimant find a lasting resolution. As illustrated in this slide with some concrete examples, Peru activated a panoply of state agencies, including, and I'll give some acronyms in the interest of time, I will not spell them out, but they're all included in the glossary to our submissions. The OGGS, the office within the Ministry of Energy and Mines that deals with social conflicts, the Office of the Ministry and Vice Ministry, again, of Energy and Mines, the Peruvian National Police, the Ministry of the Interior, the PCM, which is the President Council or the Cabinet, the Ombudsman Office, the General Directorate of Internal Government, the Public Prosecutor's Office, the Huaura Subprefecture, the Leoncio Prado Subprefecture, and the OEFA, the Regulator on Environmental Issues. Peru took immediate action to investigate the relevant facts and potentially illegal actions after the June 2018 protest and prevented the September 2018 protest. In total, Peru held nearly 30 meetings with claimant and the Peruvian community and conducted 7 mediations between the parties. Peru's efforts proved fruitful and led to the February 2019 agreement. Peru continued efforts to bring the parties together to resolve their differences, even after claimant aggravated the conflict when it unleashed the war dogs. These actions were designed to encourage dialogue and to grant claimant an opening to try to rehabilitate its reputation and relationship with the Peruvian community and rebuild that trust that is a critical ingredient for resolving the dispute, obtaining that acceptance of the mining project. When these actions taken by Peru are assessed under the applicable legal standard, including in the light of the circumstances prevailing at the time and the conditions and this long history that I have alluded to, the conclusion must be drawn is that Peru exercised reasonable due diligence and thus complied with its obligations of FPS under customary international law. But seeing its original case theory debunked, claimant no longer argues that Peru took no action. Instead, it now insists that the action that Peru took was insufficient and inadequate because Peru did not quash local opposition and forcibly put an end to the Peruvian community's protests in opposition to the project. Claimant is thus arguing before this tribunal that anything short of use of force against the rural community in late 2018 and early 2019 was unreasonable and constitutes an international wrongful act. And in the process, claimant has made clear that it does not agree with Peru's public policy of prioritizing dialogue over the use of force to resolve social conflict in its mining sector, such as the one that is the subject of this arbitration. And in an attempt to offer some legal support for its new theory, claimant invents a set of alleged obligations that it posits are contained or subsumed within the FPS standard. Claimant argues that Peru, through the PNP, should have preemptively used force against the Peruvian community and provided the equivalent of a private security service thereafter. And claimant's position is wrong for many reasons. First, FPS under customary international law does not include an obligation to take, and I quote, take all necessary measures to prevent harm, end of quote. The standard is one, as we saw, due diligence by taking measures to protect claimant's investment that are reasonable under the circumstances, not take all necessary measures to prevent harm, which is claimant's submission. The second, FPS under customary international law does not include a guarantee or warranty against all possible harm. Thus, claimant's incessant position that Peru should have prevented all possible harm to its investment does not satisfy its burden, showing that Peru failed to take reasonable action. And third, in the circumstances. And third, it would not have been reasonable or even legal under Peruvian law for Peru to preemptively use force against the Peruvian community, as claimant has suggested on a number of occasions. For example, claimant has not bothered to explain why, when, or how Peru should have singled out the Peruvian community from all the rural communities in the country to forcibly confiscate the weapons that remained in circulation as part of this historical counter-insurgency fight against terrorism and the Shining Path. But even this is another red herring argument, because claimant has not demonstrated that confiscation of weapons held by certain members of the community would have prevented any of the Peruvian community's protests or opposition to the project. Neither has claimant, and I'll come back to this point at the relevance for the legal analysis and standard that must be applied. Neither has claimant proven that Peru had an obligation to use force. Peru and Mr. Maney have demonstrated that claimant's arguments on Peruvian law concerning the use of force are simply wrong. The arguments submitted by claimants are simply wrong. In fact, they are so far-fetched that claimant was evidently unable to find any legal expert in Peru that would agree with its interpretation of Peruvian law on this issue. Instead, claimant relies solely on the legal interpretation advanced by its international counsel. Members of the tribunal, claimants' claims are based mainly on the decision of Peru not to use force. Mr. Maney is the only Peruvian criminal law expert in this arbitration that addresses the issue of the use of force under Peruvian law. And claimant decided not to call him for cross-examination. Another empty chair, another slide. We can put up claimant's slide with the empty chair. In my 20 years of practicing investment arbitration, I have never seen an opposing party that has not offered a single independent legal expert on the law of the host state, particularly on an issue that is central to its case theory. Nor have I seen that party not call the only independent legal expert that addresses a central legal issue. But not only has claimant not been able to find a criminal law expert that could challenge Mr. Maney's explanations and expert evidence, and that it chose not to call Mr. Maney, but claimant now resorts to a gross distortion of what Mr. Maney says. And you heard counsel say this morning that Mr. Maney stated that the police has no discretion under Article 8.2 of Legislative Decree 1186. That is not what Mr. Maney has said in his expert report. And we respectfully invite the tribunal to read again Mr. Maney's report, including paragraph 134, which is the paragraph that claimant's counsel has knowingly misrepresented this morning. What Mr. Maney explained is that the use of police force is regulated, not arbitrary or entirely discretionary. And he explains the situations in which that use of force can be deployed. There is an element of discretion within the regulation that is provided by the provisions that we have cited, including Article 8.2 of Legislative Decree 1186. But stripped to its core, claimant's claim is that Peru's decision not to use force against a poor rural community constitutes an internationally wrongful act for which Peru must be ordered to pay tens of millions of US dollars. In the process, claimant is asking the tribunal to second-guess the decision by the national police that using force against that community at that time in the prevailing circumstances was neither required nor advisable. And specifically, claimant is asking each of you to condemn the state's decision to promote a peaceful and long-lasting resolution of the conflict. Neither the FPS nor any other standard under customary international law could possibly support that finding. International law stresses the deference to be afforded to states regarding decisions taken based on the weighing of sensitive public policy factors, including in matters of security. And this morning, claimant unwittingly recognized that it is not for an international tribunal to dictate to a sovereign state how to use its force. Claimant's counsel said that how Peru uses force is not for the tribunal to decide. And Peru agrees. Now, concerning the operational plan, to which claimant devotes so much attention, and claimant focuses obsessively on who decided not to execute an operation, a police operation plan in mid-February 2019, and surely there will be many questions about this in the cross-examination of Mr. Saavedra. Now, Mr. President, you asked, what is the relevance, you asked claimant's counsel, what is the relevance as a matter of international law of all we have heard about who did or did not block the performance of the intervention plan? Now, claimant said in response that it is not for us, and maybe this is not verbatim, but it's fairly close. Claimant said in response that it is not for us to say who blocked the police operational plan. Now, there are two problems with that answer. First, it is yet another change of position by claimant. Because in the reply in paragraph 29, it did purport to say who blocked the operational plan. And it said, I quote, "The facts show that the police were ready to implement the operational plan on 19 February 2019 at 9 a.m., but the Mininter, the Ministry of the Interior, blocked its implementation," end of quote. So it did purport to tell you who blocked it. But in any event, that theory is baseless. It is sheer and unsupported speculation by claimant and its witnesses. And Mr. Saavedra has explained this in his witness statement, and no doubt you will hear from him again this week in response to the questions that claimant's counsel will ask on this issue. The second problem with that answer is that it does not answer the question that Mr. President posed. The answer is that it does not matter. What matters is that, contrary to claimant's contention, the police decided not to implement that operational plan, and it did so for good reason, which Peru has spent much time explaining in its submissions, but which claimant continues to ignore. But in any case, claimant's allegation that the use of force would have prevented the loss of its investment is simply not true. Again, speculation. This is legally relevant and material to the outcome of this case, because the claimant concedes that to establish a breach of the FPS obligation, it must demonstrate that if the state had acted with due diligence, it would, and I quote, "in fact have prevented the claimant's alleged loss," end of quote. Reply, paragraph 626, counter memorial 494, which is citing RLA 7, paragraph 166. Consistent with the previous conduct and practice, it is all but certain that even if the PNP, the police, had violently crushed the access road protest, the Peruvian community would simply have returned not long after their forceful removal and reestablished its civilian blockade, because that forceful removal did not solve the underlying social conflict. And we've seen this time and again in Peru and elsewhere. And we will again look at the copious amounts of evidence on the record that demonstrates that. That's not something that claimant can challenge. And as you will recall, even claimant's witness, Mr. Castañeda, admits this in paragraph 74 of his first witness statement, which you have on the screen. Now, examples of police intervention that claimant invokes prove this point. For instance, claimant invokes Las Bambas as a success. That's how claimant presents Las Bambas, a success, and proffers it as evidence that forceful removal of protesters is the correct response to such conflicts. Claimant is wrong, and the facts demonstrate that, including those that are evidenced on the annexes, the exhibits in the record. Now, the timeline that you have on your screen, unfortunately, because of time constraints, we will not be able to go back to discuss this timeline today. But this timeline shows a series of confrontations between police and local community at Las Bambas nearly every year starting in September 2015 through July 2022. After each police intervention to remove a blockade, the local community restored the blockade in greater numbers at a later point, and with each forceful intervention, additional violence, injuries, and deaths were reported. Now, this is important. The mining company in Las Bambas belatedly recognized that the use of force had been counterproductive after all, and did not address the underlying social conflict and the rejection by the local community of that mining project. Indeed, in November 2022, after 4 deaths and 97 injuries, and after the police's repeated interventions failed to resolve the dispute, the mining company itself requested that the state helped to, and I quote, "solve the problem through dialogue," end of quote. Exhibit R 227. The situation with fair and equitable treatment is not dissimilar. Now, claimant's FET claim largely overlaps with the FPS claim and fails for similar reasons. And as a threshold matter, we recall that claimants alleges that Peru breached the FET obligation through a composite act. Now, that means that claimant recognizes that the individual actions of which it complains do not, in and of themselves, constitute a breach of the FET standard. Also, claimant's FET claim has narrowed significantly throughout this arbitration. Now, claimant's accusation rests on the assertion that Peru failed to apply its own legal framework. Not only is that accusation baseless as a matter of fact, but it is also manifestly insufficient to meet the legal standard. As I mentioned earlier, the parties in this case agree that the treaty prescribes the minimum standard of treatment under customary international law. And the applicable standard under customary international law was articulated, as the tribunal well knows, by Waste Management 2, which reflects a high threshold under which a breach occurs only where state measures are. And you have the quote, which the tribunal, experienced as it is, has seen many times. And claimant has agreed that this is the relevant standard, or that it reflects the standard under customary international law minimum standard of treatment. And claimant has not and cannot demonstrate that Peru's conduct breached this standard as articulated by Waste Management 2. Among other things, a mere breach of domestic law is insufficient to meet the high threshold contemplated by the treaty and articulated by the Waste Management 2 standard. So, claimant seeks to circumvent this by arguing that Peru's alleged noncompliance amount to a repudiation of its laws. So it seems to be recognizing that a mere noncompliance with domestic law would not be sufficient to meet the standard, and so it tries to characterize that alleged non-implementation of Peruvian law as a repudiation of Peruvian law. Another label. A claimant bases its composite FET claim on 5 alleged acts or omissions. First, claimant alleges that Peru's decision to not forcefully intervene in the Access Road protest violates Article 920 of the Peruvian Civil Code or Article 8.2 of Legislative Decree 1186, which I mentioned earlier. Now, claimant is incorrect on both accounts, as demonstrated by Peru, including on the basis of the expert report of Mr. Maney, the only legal expert on this issue in this arbitration. Peru demonstrated that Article 920 of the Peruvian Civil Code does not require police intervention, forceful police intervention. This is an R5. Rather, it requires only that the law enforcement play a supporting and supervisory role with respect to a dispossessed property owner's own efforts to regain their property. It is a different situation. And likewise, Article 8.2 of Legislative Decree 1186 does not require forceful police intervention. Instead, it provides that the personnel of the National Police of Peru may use force in a series of narrow circumstances, none of which apply in this case, and that is R60. In particular, under Article 8.2c, the PNP, the police, may forcefully intervene to prevent a crime. Under 8.2e, may forcefully intervene to control any person resisting authority. Claimant's position that Peru's response to the Access Road protest was unlawful is incorrect because it rests on the premise that the police was obligated or required to use force, but it has not demonstrated that to be the case. And claimant alleges that Peru should have brought charges for contempt. This is the second, by the way. So one of the bases on which they say that there's been a repudiation of Peruvian law is the one that I just addressed. I'll address the second one. They say that Peru should have brought charges for contempt of authority against the Peruvian community for its breach of the September 2018 commitment, which you find on C-139, and the interference with attempted mine inspections. But as the tribunal may recall, on 18 September 2018, the subprefect of Huaura, Ms. Bertila Gonzalez, convened a mediation hearing with claimants' representatives and the Pran community. And during that meeting, both sides committed to, and I quote, reaching a long-term agreement that would allow them to resolve their disagreement, end of quote. However, claimant failed to address the Peruvian community's concerns, and the latter undertook the access road protest several weeks later on 14th of October 2018. But claimant argues on that basis, in the reply, that the subprefect violated Peruvian law by failing to file criminal complaint against the Peruvian community for contempt of authority, is what they're arguing, based upon on the alleged breach of the 18 September 2000 commitment by the Paran community. But Peru explained in the rejoinder that claimant is wrong for at least 4 reasons, including the fact that under the directive that governs such process, this process that led to the commitment, which is the Protective Measure Directive, Exhibit 566, proceedings for contempt of authority may only be filed in the event of a breach of a government resolution. But here, there was no government resolution in connection with the September 2018 commitment that was not complied with by the Peruvian community. Third basis. Claimant argues that Peru's approach to the Peruvian community's firearms possession shows Peru's repudiation of its laws. And to dispel the confusion created by claimant this morning, what we are talking about are 16 shotguns, 12 gauge. And this is clear from C-193, page 30. They are not long-range weapons, as claimant states in its reply. Now, the approach concerning these 16 shotguns shows that Peru adhered to the legal framework for reclaiming the firearms that the state had provided the Rondas Campesinas in the context of the countermeasures against the Shining Path, the terrorist movement in the 1990s. That legal framework that Peru has and implements follows the UN recommended approach of incentivizing the voluntary surrender of arms. And this is RLA 184. And as explained by Peru in the rejoinder, the PNP had good reason, including for the long-term resolution of the social conflict, not to act on the margins of that legal framework. Claimant's position is short-sighted and ignores the history and legal framework that Peru has enacted to address this issue. And we referred the tribunal to exhibits R264 and 265 that are relevant for this issue. Finally, claimant asserts that Peru breached its FET obligation because it failed to intervene to stop alleged marijuana cultivation in the region, and after claimant forfeited its shares in Invicta to its creditor to stop the illegal mining operation or exploitation by the Peruvian community. Now, this is important, members of the tribunal. After barely referencing these issues in the memorial, claimant dedicated the first full section of the reply to its baseless conspiracy theory that the community opposed the Invicta mine because of its alleged desire to protect what claimant presents as a community-wide marijuana business from increased attention by the authorities and to steal the mine. Now, this morning, claimant again stated that the reason why Peran opposed the project was to protect, quote, its thriving marijuana business, close quote. As explained previously, the theory of marijuana business not only lacks factual support, but it's also nonsensical. And by I mean, let me be clear, the marijuana business as a community-wide thriving business lacks support. The evidence does show that there were marijuana cultivation. I don't know whether they have been completely eradicated, but there is evidence on the record that there were some marijuana cultivations in the region. But even claimant's own evidence shows that it was not community-wide as it now argues. But that theory is also nonsensical, as we've explained. The opposition of the Paran community was designed to have the opposite effect, and that is to attract attention to the Invicta project. And that is exactly what it did. And this theory, which counsel now argues this business, the thriving business, which is nothing but sophistry, is irresponsible and reckless. And we've said this in our submissions, and they still today insisted on presenting that reckless theory. Because in addition to being false, it shows that claimant has no reservation about accusing an entire rural community of criminal conduct. The tone that you heard this morning from claimant shows the contempt and disrespect with which it holds and always held the Paran community as a whole. As for the illegal exploitation of the mine by local residents after claimant lost its investment, it is simply irrelevant and immaterial. And like the marijuana conspiracy theory, was barely mentioned in the reply. In fact, it was buried in 2 paragraphs in that submission. And yet this morning, you heard claimant state that its entire case theory is that Paran took the Invicta project to mine it for itself. Again, I think it's perhaps not verbatim, but very close to what we heard this morning. Claimant's case theory is being made up as claimant goes. Those 2 paragraphs are Memorial 191 and 192. And the fact that these conspiracy theories are made for arbitration is evidenced by the fact that contemporaneously claimant never argued that the illegal crops, which were known to exist at the time, or the threat to legally exploit the mine, were the reasons behind the Paran community's opposition to the mining project. They were not. And the evidence shows, and claimant acknowledges, that the opposition was motivated instead by concerns for the environment, a territorial dispute with Laxanga, and the desire to obtain the same benefits that claimant had offered to the neighboring communities. This is reflected in the evidence, not the conspiracy theory. Claimant has simply fabricated that theory in an attempt to distract from the fact that it was claimant's own actions that prompted that opposition from the community, based on that mismanagement of community relations that we discussed earlier today. But in any event, the evidence shows that Peru intervened by seizing and destroying marijuana plants, making arrests, and planning and executing an operational plan to end the exploitation of the Invicta mine. Now, that evidence, acknowledged and unrebutted by claimant, shows that law enforcement authorities in Peru did, in fact, take action against that illegal activity. In sum, the evidence and expert opinion on the record shows that it is manifestly false that Peru's conduct constitutes a repudiation of its laws. There simply was no breach of customary international law or of the treaty by Peru. But Peru's actions are also not arbitrary, a component of the FET standard. As demonstrated by Peru in this arbitration, including on the basis of Mr. Maney's expert report, under Peruvian law, the Peruvian National Police has discretion to decide whether force is necessary under the circumstances. Its decision not to use force in this case was justified and reasonable, as the PNP was concerned about the violent confrontations, the loss of life, and the durability of the resolution to the conflict. The results of the police December 2021 intervention to remove members of the Paran community from the mine shows that such concern was justified. The Peruvian authorities justifiably concluded that that force was not justified, and that dialogue should be favored to secure a peaceful and lasting resolution to the social conflict. And far from arbitrary, this is reasonable and prudent. In addition to the above, and I'll try to be brief with respect to this component of their theory. In addition to the above, and the above amply justifies dismissal of claimant's FET claim, but if more reasons were needed to dismiss that claim, there's another reason why such claim must be dismissed, and it's the following. Claimant has failed to establish the existence of a composite act. As explained by Professor Crawford, and I quote, "A composite act is more than a simple series of repeated actions, but rather a legal entity, the whole of which represents more than the sum of its parts." Claimant has not established the existence of a legal entity, nor has claimant demonstrated that each of the individual acts constituted the alleged composite act were, and I quote, "sufficiently numerous and interconnected to amount to a pattern or a system." The claimant has not met this standard for several reasons expounded in Peru's briefs, which in the interest of time I will not repeat, but instead I respectfully refer the tribunal to sections 4C of the Cantor Memorial and also 4C of its rejoinder. And likewise, claimant has not demonstrated that each of the individual acts constituting this alleged composite act had an adverse effect on the investment, which is a relevant factor. And for that, I refer the tribunal to CLA 71, paragraph 263, and CLA 82, paragraph 670. Thus, claimant has failed to meet its burden of proving a composite act under international law. And accordingly, we respectfully submit that the tribunal must reject claimant's FET claim. Now, I will go into the last claim on expropriation, but before I do so, let me turn to my team to see if we are doing okay with time. I am advised that I may not have time to go over the entirety of the presentation that we had about expropriation. I will be brief. Before I do so, I again respectfully refer the tribunal to our pleadings. The fact that we're not able to address them today does not mean that we have in any way lost confidence in the submissions that we have made in those pleadings. Now, claimant's expropriation case is unusual. It rests entirely on the actions of third parties, namely the Paran community and PLI Wauda, its creditor. Now, claimant does not argue that any affirmative action by Peru expropriated claimant's investment. Rather, claimant alleges that Peru's decision not to use force to try to remove the access road protests and silence the Paran community protesters affected a direct and indirect expropriation. And claimant, of course, is wrong on both counts. For its direct expropriation, it argues that that the Paran community's access road protest was attributable to Peru, and that this protest led PLI to cease claimant's investment. And according to claimant, Peru therefore directly expropriated its investment. But that claim is based on wrong premises and flawed logic. And first and foremost, the direct expropriation claim rests on this claimant's outlandish theory that the Paran community committed an outright seizure of the investment through the protest, and that the action of that rural community is attributable to Peru under international law. But we've demonstrated that the actions of the members of that rural community are not attributable to Peru under international law or even domestic law. And in addition, that claim fails because the forfeiture of claimant's shares in Invicta does not constitute a direct expropriation. I will, in the interest of time, skip over the discussion of formal seizure of title and how that is understood in international law. I will emphasize again that the only conduct that by Peru that claimant invokes for its direct expropriation claim is Peru's alleged omissions, specifically that Peru did not forcefully remove the access road protest. And here I mentioned that according to claimant, when a state knowingly allows by its omissions a third party to take possession of that property, such state can be liable for direct expropriation, and they rely on Wiener Hotels and AMCO. And I was surprised to hear this morning that claimant's counsel, in passing, again relied on those two legal authorities, because we explained in our rejoinder why those legal authorities were inapposite and did not support their case. Because in those cases, the states played a much more active role. They affirmatively enabled the expropriations. And of course, that's not the case in the present arbitration. And Peru demonstrated this in rejoinder, including in paragraphs 743 and 744. But claimant simply ignored that argument and that distinction of those cases from the present case, but they still relied on those authorities this morning. But in any event, we've demonstrated that Peru did not knowingly allow any third party to take possession. And here, I refer the tribunal to, and if we can skip ahead to the rejoinder table 6. It's a table that spans 10 pages of our submission of our rejoinder. You will not find it in the slides because it's such a long table. But that table 6 in our rejoinder includes the numerous affirmative steps that Peru took to support claimant and broker a resolution to the social conflict, repeatedly urging the Peruvian community to lift the access road protest. Okay, in the very few minutes that I have left on direct expropriation, claimant argues that it's a composite act and a creeping expropriation, and alleges that a clear pattern of acts by Peru, which claimant never specifies, it says that that unspecified pattern amounts to creeping expropriation that claimant characterizes as Peru letting the Peruvian community act with impunity. But however, similar to its FET claim, claimant has not even proven the existence of a composite act by Peru. And also, claimant treats composite act and creeping expropriation as one and the same. I've already addressed the composite act and how it's understood and defined by Professor Crawford. Let me, in the interest of time, skip ahead. Once again, and I've explained this, the record contradicts claimant's allegations that Peru consistently took no action. In fact, Peru intervened early on and often to mediate claimant's social conflict. And again, we respectfully refer you to Table 6 of the rejoinder. And this was not only by one entity or a state organ, but by many, including the police. The claimant's indirect expropriation claim fails for so many reasons, including that it does not meet the fundamental and decisive effects test that is widely recognized by international law and the jurisprudence, again, as being decisive in determining whether an expropriation has occurred. And this is also reflected under Treaty Annex 812, which is very important when assessing whether an indirect expropriation has been committed. Claimant must prove that Peru's measures had an expropriatory or economic impact on its investment, and to be expropriatory, the economic impact must amount to the complete or near complete deprivation of the value of claimant's investment. But that factor is simply not met in this case, including for two basic reasons. And I will go quickly over these reasons, and then I will cede the floor to my colleague, Mr. Brian Bobasaro. First, the measures that claimant attributes to Peru did not result in a complete or near complete deprivation of the value of claimant's investment. And to recall, PLI, claimant's creditor, ceased the investment as a direct result of claimant's decision to pledge its shares as collateral in the PPF agreement, claimant's failure to secure a social license from the Peruvian community, claimant's failure to secure the necessary regulatory approvals to commercially exploit the Invicta mine in time to meet its PPF obligations, claimant's failure to secure reliable ore processing, and claimant's 14 events of default under the PPF agreement, including failure to achieve commercial exploitation by the contractual deadline. And even claimant admits that not all of those 14 instances of default are related or can be linked to the blockade. And second, far from having suffered a complete or near complete loss of value, claimant investment held significant value at the time claimant lost its PLA, its investment to PLA. And with this, this is the last comment that I make. Shortly before PLA Waura ceased Invicta's shares, PwC conducted an independent appraisal of the investment and valued it at $13.4 million US dollars, far from zero or even negative as claimant alleges. Further, a mining consortium, and this goes, Mr. Garibaldi, to your question about the corporate chain, A mining consortium called Lonely Mountain indirectly acquired PLA Waura's right to seize the Invicta mine, thereby demonstrating that the mine did have value as an investment. And this is C53 and C55. In Steag v. Spain, the tribunal held that, and I quote, when an investor from the same market is willing to invest in a project, it is clear that the economic value of that project has not been eliminated. End of quote. This is RLA 192.
How much did they pay?
Is it the... You don't know. It's not on the record. I'm confirming whether it's on the record, Mr. Garibaldi. It's not on the record. It's not on the record, but again, we know that shortly before the shares were seized by PLI, PwC valued the investment at $13.4 million. And this is in C55, page 2, and R193, clause 3. And with that, Mr. President, and with your indulgence, I cede the floor to my colleague, Mr. Brian Bombasaro, to address the tribunal on the issue of damages.
Good afternoon, Mr. President and members of the tribunal. My name is Brian Bombasaro, and I will address claimant's damages claim. As Peru showed in the pleadings, claimant is not entitled to any compensation from Peru. Any damages claimant may have suffered based on its investment in Invicta were not caused by Peru. In any event, claimant's claim for $41 million and the calculations by accuracy that produced that sum are flawed and grossly overstated. To calculate its alleged damages, claimant set the valuation date as 26 August 2019. The significance of this date, according to claimant, is that it is the date on which, quote, Lonely Mountain seized the claimant shares in IMC, unquote. That's in Memorial Paragraph 325. Claimant's selected valuation date is not a date on which claimant alleges any wrongful action by Peru. It's not even a date on which claimant alleges any wrongful omission by Peru. Nevertheless, claimant argues that on 26 August 2019, Peru became responsible for $41 million of alleged damages. The fact that claimant has not even alleged wrongful conduct by Peru on the date when claimant asserts that Peru became responsible for the lost investment is emblematic of a broader disconnect between claimant's alleged damages and the alleged causes of those damages. Claimant's alleged damages were not caused by Peru. As Peru has demonstrated, claimant's alleged damages were caused by the actions of Lonely Mountain, or more accurately, by the actions of PLI Waura, which Lonely Mountain eventually owned. Claimant also bears responsibility for any damages caused by the Peron community and for any damages caused by claimant's own decisions and claimant's own actions. The lack of a causal link between claimant's alleged damages and any alleged wrongful conduct by Peru should be dispositive and result in an award for zero damages. If, however, the tribunal were to ascribe any damages to Peru, such damages would need to account for claimant's contributions to its own injury. Furthermore, in no circumstance should claimant be awarded or otherwise credited with any alleged damages that are based on a merely future or prospective investment, and claimant has requested such damages in this case. Claimant's request for those damages should be denied because the treaty explicitly applies only to investments made or acquired in Peru. Lastly, any damages award would need deductions to account for the errors and unfounded assumptions in the calculations that generated the amount of claimant's damages claim. I will discuss in turn each of these defects in claimant's damages case, starting with causation, and then claimant's contributory fault, claimant's merely prospective investment in the Malay plant, and lastly, quantum. First, as the tribunal knows, claimant is not entitled to any damages unless claimant proves it had an injury that was caused by the internationally wrongful act. The ILC commentary explains that this condition requires a claimant to prove both causality in fact as well as proximate causation. In the damages context, factual causation means that if the wrongful act had not occurred, then the alleged injury would not have occurred. At least conceptually, causality in fact is relatively straightforward and uncontroversial. With respect to proximate causation, claimant wrongly argues that claimant simply must show that damages were, quote, a normal, foreseeable, or intended consequence of the state's wrongful act, unquote. That's from claimant's skeleton argument at paragraph 101 and reply paragraph 892. This attempt by claimant to reduce proximate causation to a test for any one of those three criteria is squarely refuted by the ILC commentary, where the ILC discusses proximate causation in its comment 10 to Article 31. The ILC expressly warns that, quote, in international as in national law, the question of remoteness of damage is not part of the law which can be satisfactorily solved by search for a single verbal formula, unquote. In fact, the source that claimant cited for its proposed three-pronged test, which is the Rapinski and Williams treatise, itself indicates that the ILC rejected that same three-pronged test in favor of a, quote, more cautious approach. That's at pages 136 to 138 of CLA 151. In addition to the ILC commentary, international jurisprudence has examined and explained proximate causation. Peru presented this jurisprudence in Rejoinder Section 5A1. The legal analyses in those decisions identified the following criteria for proving proximate causation. 1. Claimant must prove that an uninterrupted and proximate logical chain leads from the initial cause to the final effect. 2. When there are several causes acting together to injure an investment, the underlying cause is the legally dispositive one. 3. Claimant must prove the state's measures were the operative cause of the investment's failure. 4. Claimant must prove that its losses have arisen from a breach of the treaty and not from other causes. These are the benchmarks for identifying proximate causation, and claimant has not met them. In fact, in the memorial, claimant did not submit any analysis at all on damages causation. Then, in the reply, claimant ignored the vast factual record in this case, arguing superficially that the causal chain from the alleged treaty breach to the alleged damages comprises just two simple links: the Peron community's access road protest and Peru's decision not to use force to annihilate that protest. Claimant even says in reply paragraph 918 that, quote, no other factors contributed to the claimant's loss of its investment, unquote. Claimant deliberately omits from its purported causal chain the genesis of the access road protest, essentially treating that protest as if it had originated spontaneously through no fault of claimant's own. Claimant wants you to ignore its responsibility for its broken relationship with the Peron community. Claimant also wants you to ignore the contract in which claimant signed away its ownership rights to the Invicta mine as loan collateral, and claimant's 14 breaches of that same contract, and the outstanding regulatory requirements for operation of the Invicta mine, and claimant's failed pursuit of reliable ore processing, which claimant needed to convert any raw ore into marketable minerals. Claimant wants you to ignore all these facts because each one reveals claimant's superficial causal chain to be removed from reality and insufficient to establish proximate causation or even causality in fact. Peru demonstrated those failures in Counter Memorial Section 5B1 and in Rejoinder Sections 2D and 5A2. Nevertheless, claimant insinuates that its two-link causal chain should suffice to flip the burden of proof over to Peru to prove an intervening or superseding cause. That's in reply paragraph 927. Claimant is incorrect given that claimant failed to make a credible case on but-for causation or on proximate causation. But in any event, Peru has satisfied any such burden of proof through the evidence and the analyses that Peru presented in the pleadings I just mentioned, Counter Memorial Section 5B1 and Rejoinder Sections 2D and 5A2. To recall, the causes of claimant's alleged damages under any of the relevant legal standards, such as the initial cause, the underlying cause, the operative cause, the proximate cause, the but-for cause, the underlying cause, the intervening or supervening causes, are those facts that I just referred to moments ago and which claimant wants you to ignore. 1. Claimant's botched relations with the Peron community that was the genesis of the Access Road protest. 2. Claimant's contract pledging its investment as loan collateral. 3. Claimant's 14 breaches of that same contract. 4. The outstanding regulatory requirements for the Invicta mine. And 5. Claimant's failure to secure any reliable ore processor. In the pleadings, besides simply ignoring these facts when claimant posits a two-link causal chain, claimant also relabels these facts as, quote, concurrent causes and criticizes Peru for not, quote, making any references in its counter-memorial to the principles on concurrent causes, unquote. That's reply paragraph 899. However, this relabeling maneuver by claimant distorts Peru's causation analysis. In fact, Peru never referred to concurrent causation principles because they are not relevant to this case. Because no alleged breach by Peru was a proximate cause of any alleged damages, Peru simply is not responsible for any damages. Whether acts by claimant, by PLI Waura, or by the Peron community might be concurrent causes would have no bearing on claimant's claims against Peru. Moreover, even if a treaty breach were deemed a proximate cause of any alleged damages, contributory fault principles would apply, as claimant has acknowledged in reply paragraph 901 in the first sentence. Specifically, in a scenario where the tribunal deems an alleged treaty breach to be the but-for and proximate cause of any alleged damages, the tribunal would need to make deductions from those damages for claimant's contributory fault. As summarized in rejoinder paragraphs 822, 858, and 860, this is a case where the claimant was hoisted by its own petard. Claimant's entire case is an attempt to deflect blame onto the government for not doing even more to try to save claimant from the results of claimant's own mistakes and claimant's duplicitous conduct toward the rural communities. That's a textbook case for applying contributory fault and for doing so with 100% of any damages. Peru explained this in Counter Memorial Section 5B2 and Rejoinder Section 5B. Based on the foregoing, claimant's damages claim should be rejected entirely based on causation or alternatively based on contributory fault. A portion of claimant's damages claim, $8.9 million of it, should be rejected for a third reason, which is that this portion is impermissibly based on a prospective or future investment in the Malay plant that claimant never made. As shown in Section 5C of both the counter memorial and the rejoinder, the treaty applies only to covered investments. To be a covered investment, the text of Treaty Article 847 requires that an investment must have been made or acquired in Peru. Claimant admits it never made or acquired any investment in the Malay plant. That's in reply paragraph 1020. Yet, claimant's claim for $41 million is expressly based on claimant hypothetically investing in the Malay plant. Without an investment in the Malay plant, claimant's own experts calculate claimant's damages to be a maximum of only $32.1 million. The difference between those two alleged amounts, $41 million with the Malay plant and $32.1 million without the Malay plant, is $8.9 million. As a matter of law, claimant cannot be awarded this extra $8.9 million that is based on an investment in the Malay plant that claimant never made or acquired. Furthermore, even if any damages were due to claimant, the tribunal should not rely on the $41 million amount or even the $32.1 million amount that claimant's experts estimated as damages. Those estimates are overstated for many reasons that are summarized in Rejoinder Section 5D and which are explained in details in the Alex Partners second report. Alex Partners will present its reports next Monday, but for now I wish to emphasize 2 points. First, those corrected amounts proposed by Alex Partners, which are $20.5 million and $22.5 million under the alternative or production scenarios posed by claimant, reflect only the corrections that Alex Partners could quantify based on available information. But there are several additional errors in accuracies damages calculations such that the 2 corrected amounts by Alex Partners require further downward adjustments. Second, Alex Partners' corrected calculations are without prejudice to the legal barriers to any damages award that I have summarized today, such as claimant's failure to prove causation and claimant's contributory fault. Those legal barriers to claimant's claims should be dispositive and result in 0 damages. Thank you.
Thank you. Thank you very much, counsel. Does that conclude our, I'm sorry, it doesn't. We have an important speaker.
Thank you, Mr. President. Good afternoon, Mr. President and members of the tribunal. I respectfully request your indulgence to make some initial remarks on behalf of the Republic of Peru. Water is like gold in the Paran community. It's a common phrase chanted by locals in Paran, a Peruvian rural community located in the direct area of influence of the mining project at stake in this investment arbitration. In Peru, Paran is known for 2 things. Nearly 75% of its population is blind due to retinitis pigmentosa, a genetic mutation inherited across generations, and the reputation as home of the sweetest peaches in the country. It is said that despite blindness, peaches are sweet in Paran. It may sound contradictory, but blindness and sweetness coexist in Paran. Peru is a global leader in the mining industry and is recognized as having one of the largest and most diversified mineral reserves on the planet. It is among the world's top producers of copper, silver, lead, zinc, gold, and other precious metals. Peru's mining industry is one of the most important sectors of its economy and views foreign investment in that sector as a key driver to advance the development of the country. Peru's mining industry accounts for 8.3% of GDP, while mineral exports represent 58.9% of the country's total exports. The country is among the major producers of mineral commodities in the world. The mining tradition in Peru dates to the pre-Inca times and continues through the Inca, colonial, and republican periods. In each of those historical stages, mining has been one of the major activities in the country's development. Hand in hand with the need to provide a stable and predictable framework conducive to attract foreign investment in the mining industry to its shores, Peru has recognized the need to strike a balance between two policy objectives: advancing the development of its extractive industries and ensuring that the social and environmental impacts of such industries are appropriately addressed. The Canada-Peru Free Trade Agreement can be considered as pioneering pursuit of the goal of achieving the right balance between the protection of foreign investments on one hand and the recognition of the right to regulate in the public interest on the other hand. These two policy objectives, enshrined in the Canada-Peru Free Trade Agreement, are equally compelling and urgent, equally legitimate and genuine, equally essential and inescapable. It would be erroneous to consider investment treaties as mere text in a vacuum, ignoring the fact that they are shaped and influenced by the political, economic, and social context in which they are anchored. This balance is reflected in the provisions on corporate social responsibility of the Canada-Peru Free Trade Agreement. Paradoxically, the investment treaty claimant has invoked to bring a multimillionaire claim against the Republic is the same investment treaty that reminds investors like claimant in this present arbitration of the importance of incorporating internationally recognized standards of corporate social responsibility in their internal policies. Through international corporate social responsibility norms, the extractive industry widely recognizes the vital need for private companies to obtain community support before commencing mining or other extractive industries. In accordance with the OECD guidelines for multinational enterprises and the OECD due diligence guidance for responsible business conduct, stakeholder engagement with the communities that investors interact with is characterized by a two-way communication. It involves the timely sharing of relevant information needed for stakeholders to make informed decisions in a format that they can understand and access. To be meaningful, engagement involves the good faith of all parties. Meaningful engagement with relevant stakeholders is important throughout the life of an investment project in the mining sector. In particular, when the enterprise may cause or contribute to, or has caused or contributed to, an adverse impact in the area of influence in which it plans to operate. As Counsel for the Republic has explained over the course of this investment arbitration, in light of relevant customary international law, Peruvian law, and industry principles, claimant should have been aware that it was required to obtain community support before developing the Invicta mine. The constitutional rights of rural communities in Peru are enshrined in Articles 2 and 89 of the Constitution. Article 2 includes amongst the list of fundamental freedoms the right to ethnic and cultural identity. Article 89, for its part, specifically relates to rural and native communities and provides that the state respects the cultural identity of rural and native communities. That same article establishes protection for the rights of rural communities to autonomy and free disposition of their lands, mandating that such commitments are autonomous in their organization, in communal work, and in the use and free disposal of their lands, as well as in economic and administrative matters within the framework established by law. Members of the tribunal, claimant had the opportunity to engage in a meaningful dialogue with all the stakeholders in the area of influence of its mining project, including the Paran community, and to seek to prevent any adverse impacts directly linked to its operations. It failed to do so. Like blindness and sweetness that cohabit in the community of Paran, like gold and water that cross paths, mining industry and rural communities can coexist if measures adopted to address environmental, health, and community concerns are appropriately implemented with due diligence. Peru forcefully advocates for policies to further advance its
Ma'am,
mining.
Excuse me, but we're past our appointed ending time, and I don't want to cut off an important statement, but do you have a sense of how much longer you'll need?
Probably less than 1 minute. Peru forcefully advocates for policies to further advance its mining industry as an engine to economic growth, and it incessantly urges mining companies to engage in a constructive dialogue with all the relevant stakeholders in the area of influence in which they operate. The seeming dichotomy between two apparent opposite interests vanishes if one considers that the twofold policy objectives at the heart of this investment dispute coexist as two sides of the same coin: Peru's path towards its own development. In summing up, members of the tribunal, it is the Constitution of Peru, it is customary international law, and it is justice. Having said that, I would like to conclude my remarks by extending the deepest respect and appreciation to the members of the tribunal on behalf of the Republic of Peru.
Well, thank you very much for that, ma'am, and we thank the respondents for a very interesting and wide-ranging introductory presentation. I take it we're now done? Okay. Is there any last administrative business, anything we need to tend to? If not, we will see you, wish you a pleasant evening, and we'll see you tomorrow at the same time.
Thank you.
The session is adjourned.